Senator Coppin.
So, Madam President, before we left for tea, I was speaking a bit about the SSA from the perspective of efficiency. And, Madam President, I want to return to that particular discourse and that line of reason because it was raised in this Honorable House by Senator Mahabir as perhaps the foremost reason why he would choose to support or not to support this particular bill. And, Madam President, for the record, I would like to take this Honorable House back to some of the recommendations that would have been born out of the inquiry into the 1990 coup, because they are very instructive in the way we think about security agencies and intelligence agencies going forward. Madam President, may I refer this Honorable House to the said report, page 788. And in this report, Madam President, it is reported by one Mr. Harvey, who was told by the Commissioner of Police, Mr. Luis Rodriguez, that the major problem with the special branch during the 1990 insurrection period was its lack of efficiency and effectiveness. This was 1989, and the special branch was the official agency providing information and intelligence to the executive and the diplomatic corps. The Army and Coast Guard collected their own information or intelligence for their own purposes. And, Madam President, he goes on to say that the special branch did not share information and intelligence with the other agency, with any other agency, including the Defense Force. He says the special branch's reluctance to share information was rooted in its distrust of other agencies. Customs and immigration were seen as departments riddled with corruption. The Defense Force was perceived by the special branch as considering itself superior to the police. And Colonel Brown, Madam President, he reports to the Commission that there had always been a rivalry between the police and the Defense Force. And he says that Mr. Harvey ought to have volunteered information about the Jamaat to us and not wait for us to ask for it, but he never did. Mr. Mervyn Giuseppe, he reports, our remit was not to share intelligence with the Army. So, Madam President, what this report shows is that there was a level of distrust amongst agencies. There was an inferiority and superiority complex pervading amongst the infrastructure, the intelligence agencies of this country. And there was belief that some were corrupt and therefore ought not to be, for want of a better word, put into the loop. Now, Madam President, I don't know to what extent these considerations now exist, but it would be remiss of us as policymakers, aware of what happened in the past, to ignore such considerations and pretend that it is not a possibility that such lack or silencing of information can occur again. And we all knew what happened as a direct consequence of not sharing information between these agencies of state. And at that time, the Commission of Inquiry spoke more or less to about four agencies, four key agencies: the Special Branch, the Defense Force, the Police, and I think Customs. But there, as I said earlier, there is now a proliferation of security agencies, each with their own remit and who is just and who are important to national security in their own right. So, given that it happened in 1990 and the results are well known, we must do our best to prevent such incidents from happening in the future, Madam President. And that was 1990. But if we fast forward, we saw our rising out of this security failure was the SIA in 1994. And then we had the SSA in 1995, which arose for a particular set of crimes relating to narcotics. And, Madam President, the opposition would not like to admit, but this act is well known that this act was not passed by any special majority. So, to come here now and to act as if a special majority is somehow needed, to me, is disingenuous, Madam President. It is disingenuous. There is a prevailing thought, Madam President. There is a prevailing thought, Madam President, that the opposition the only thing sincere, the most sincere thing about the opposition is insincerity.
Please.
Yes.
Don't go there, please.
So, Madam President, and this is another indication of another indication of the UNC. Huh?
Please be allowed to hear him. Can I be allowed to hear Senator Coppin? All other senators are to remain silent when the senator is speaking. Senator Mark, this is not his maiden speech.
So we can interrupt.
You, Senator Coppin.
So, Madam President, that said, what we had during the period from 2003, we had the establishment of the SORT, which was then in 2010 subsumed within the ambit of the SSA. In 2010, Madam President,
what did you have for tea? Continue, Senator Coppin.
Sorry.
So, Madam President, we had in 2010, we had SORT being alleged to be unlawfully operating, and we had this agency being vilified, and we had this agency being subsumed within the SSA. And since then, Madam President, we've had a proliferation of different agencies by different names, different anagrams. We had the SIA being subsumed. We had the NIA proposal, Madam President. And I think this was pursuant to the 2011 Gibran report, a steering committee report of a 67-page comprehensive document. And in this report, it spoke to merging the SIA SORT with the SSA to form the NIA and to abolish the SSA. We also had the NSIA plans, right, Madam President? And these plans entailed, and it was announced by Brigadier John Sandy, one of the many ministers of national security that the last administration had, and I think that is one of the reasons why they were so inconsistent with their approach to national security. They simply had too many ministers of national security, Madam President. So, and they don't like when you speak the truth, Madam President. They get particularly perturbed when one speaks the truth.
If you speak.
When we speak the truth, Madam President. And we had the NSIA proposal, we had the NSIA plans, right? And then we had the formation of the NOC, Madam President, in exactly the same way that the SIA was created by a cabinet minute, Madam President. So, for the opposition to come and to claim illegality and to claim that we have the SORT that was operating illegally, they really have no moral standing.
Senator Coppin, you have 5 more minutes.
They really have no moral standing in which to base such allegations. So, Madam President, what we had was a proliferation, but we had the NSIA, we had the SIA, we had the NOC, but we had a opposition leading in government that simply did not understand the ABC of national security. And that is the problem. So, Madam President, before I take my leave, I want to deal particularly with the issue of safeguards, because the constitutional safeguards are something that the opposition would have said today was missing, and therefore there was not enough checks and balances. But if we look at the inter-articulating pieces of legislation, we would see that there are safeguards contained within the SSA Act as well as the Interception of Communications Act. Now, these safeguards are important because they provide the checks and balances that are needed for any agency to be constitutional and to be proportionate in the way it operates national security in this country. So, Madam President, I want to speak perhaps firstly because the member for Siparia, the opposition leader, would have spoken about the right to privacy as being one of the reasons why the bill was not proportionate. But we have in the SSA Act, we have section 5(2), which speaks about the employees of the agency taking the oath of allegiance. This should help with protection of privacy, because oath of allegiance and secrecy, Madam President, and that oath is set out in the schedule. We have regulations that can be made, and Senator Mark would have spoken about it. He said that for 21 years there was no regulation, but he conveniently forgot that for a large period of time the UNC was in office. So they had the opportunity to pass regulations and they did not. So it's also very disingenuous of him. And we had, Madam President, we have, in addition to the regulations, we have offenses for breach. We have disclosure of information. In section 8, noted there shall be no employee of the agency shall disclose information unless it is in the course of the performance of their duties, Madam President. So there are safeguards within the SSA Act. Madam President, within the Interception of Communications Act, I want to point out a number of safeguards, constitutional safeguards. For instance, Senator Mahabir would have spoken about there being no warrant, but in fact, a warrant is needed, and there's provision for a judge to give a warrant for the interception of communication, and that is the only way in which communication can be admissible in court. This is section 6(2). And there is also the provisions as to how that warrant should be issued in section 8(1). The time period in which it can be issued for 90 days, which is contained in section 10. And there is also, Madam President, another constitutional safeguard contained within the said legislation that the judge, where section 14, where a judge issues a warrant, he shall issue such directions as he considers appropriate for the purpose of requiring the authorized officer to make such arrangements as are necessary. And it speaks about the directions would speak to the extent of to which intercepted communications is disclosed, the number of persons to whom any of the communications is disclosed, and the extent to which it should be copied. So, and finally, Madam President, within that said legislation, there's an offense in section 23, which speaks to a person who intentionally discloses information obtained by means of a warrant. So, in contravention of the Act. So, confidentiality is protected, Madam President, and there are offenses within the same said Interception of Communication Act, which has been in operations for so long, and I'm sure the opposition knows about that, which can provide that constitutional safeguard. So, Madam President, in closing, I would like to say that this bill is proportionate, it is reasonable, it does not intrude, it does only so much as is necessary to protect national security. It strikes the right balance between the protection of life and liberty and private life and family life. It is important because we are at a stage now where our country is rife with crime, and therefore it is effective. It's one of the only effective ways to ensure that the crime rate is brought down. And with that, Madam President, I thank you.
Senator Ramdeen.
Madam President, thank you. As I rise to make my maiden contribution in the Senate, Madam President, I would like to thank Almighty God, the Leader of the Opposition, and you, Madam President, for the opportunity to contribute in what I consider to be a very important debate on very crucial legislation that has been proposed by the government in this matter. I had planned my contribution, Madam President, in a particular order, but having regard to what has fallen from the two speakers of the on the government side, I think that there are certain issues that I wish to correct immediately. And the first of those issues, Madam President, deals with the issue of safeguards. The Attorney General has indicated that there is no risk to the rights that are enshrined and guaranteed to us and the citizens of this country because there are sufficient safeguards in this legislation. And the Attorney General went on to indicate what he considered to be the appropriate safeguards that are inherent or expressly apparent on the face of the legislation that we have before us. The first safeguard that the Attorney General indicated was that the SSA is subject to the Auditor General. Well, Madam President, with respect to that, perhaps the Attorney General would want to indicate to this Senate what is the record of the Attorney General, of the Auditor General, when it comes to safeguarding institutions over which the Auditor General has authority. And let us take, for instance, we have already in the public domain the record of the Auditor General with respect to the THA, which is abysmal. The record of the Attorney General, the record of the Auditor General, pardon me, Madam President, with respect to the SSA was that in 2015, the Auditor General produced reports for the SSA with respect to the period 2003 to 2008. So we are still awaiting 08 to 015. We're in 2016 now. So we are 8 years behind with respect to the Auditor General. And the Attorney General, who is supposed to be the guardian of the public interest, and that is a phrase that is not to be taken lightly, ma'am. The Attorney General, who is the guardian of the public interest, will come to this Senate, propose legislation, and indicate that the appropriate safeguards that are to protect the rights of the citizens of this country must be the Auditor General. Well, we don't accept that as a safeguard by the opposition. The second safeguard, Madam President, is with respect to annual reports. Madam President, the only way in which we can judge if there are appropriate safeguards for legislation that touches, concerns, and may infringe the rights of the citizen is to test those safeguards by their record, as we will test the record of the SSA, as Senator Mahabe has indicated. When you look at the annual reports of the annual reports with respect to the SSA, in 2015, you had annual reports for 09 to 2013. So we're 3 years behind in relation to that. And that is also considered an appropriate safeguard by the Attorney General. But I think the most material safeguard, and in Trinidad, we have a saying that we have a very short memory, Madam President. But the Attorney General has indicated that an appropriate safeguard for this type of legislation, this type of draconian legislation, is that you have a joint select committee of Parliament that is oversight, that will provide oversight over the SSA. Madam President, we have just had the experience of what took place with respect to Petrotrin. And when questions were asked of a committee with respect to Petrotrin, legal professional privilege was raised as an objection to producing documents that were relevant to decisions taken by this Attorney General with respect to litigation conducted by Petrotrin. Not on my advice. I also, Madam President, no, I wish to say this. Let me put it on the Hansard record because I want to respond to the Attorney General in the appropriate place in Parliament. That when the Attorney General sought advice from me, my advice to the Attorney General was to continue with the litigation. So let me put it on the Hansard record because the advice that the Attorney General is speaking about, Madam President, I want to reply because he cannot be allowed to make allegations like that against people's character in the Parliament. The Attorney General was relying on advice from senior counsel. I was junior counsel, and I delivered advice to junior counsel, as junior counsel. I indicated to the Attorney General in a meeting, not in writing, not in writing. So the fact that it was not in writing.
Don't respond to him, don't respond to him.
Don't let him distract you.
Excuse me, could we have silence, please? Please, Senator Ramdeen is on his feet. Could we all listen in silence?
Thank you, Madam President, for your protection. The JSC, well, let me just finish the point on the JSC, which is this. We will end up in a position, Madam President, where you will end up before a JSC, and when the questions are asked, the issue of national security will be raised and it will be shut down so that there is no safeguard in a JSC. So, with respect to all of the safeguards that have been suggested by the Honorable Attorney General, they amount to absolutely no safeguards at all.
Zero zilch. Not.
Now, Madam President, I would like to underlie my contribution to this House by a saying that is renowned about sacrificing your rights for the purposes of security. And it is this: a people that are prepared to sacrifice liberty and their rights in the hope of achieving security deserve neither. So that if this government...
You talking? Man, listen, I know,
Say it again, say it again.
A people that are prepared to sacrifice liberty and their rights in the hope of achieving security deserve neither. But, Madam President, I am happy in my maiden contribution that I am being disturbed by these sounds from the other side because there is a particular issue about the state of emergency that I will get back to, but let me deal with it now since it was raised by the voices on the other side. And it deals with the Honorable Attorney General as well. And I was happy with Madam President's ruling that we can refer to what was said in the debate in the other place. Because the Honorable Attorney General, who at times is a mind of useless information, said in the other place, with respect to a state of emergency.
Senator Ramdeen, just please. Please. It is your maiden contribution, but you still standing orders still apply. So don't impute improper motives or don't say things like that about other members of either house, okay? But you may proceed.
In the other place, Madam President, the Attorney General had this to say. A state of emergency, we saw it in the figures. We saw in 2012 a drop down to 383. I could tell you, as Attorney General and Minister of Legal Affairs, millions of dollars in false imprisonment, in malicious prosecution, nearly 7,000 people detained, released, washed. Those were the words of the Attorney General. Let me correct that, Madam President, because I was retained on behalf of the Attorney General to defend all of the state of emergency matters arising out of the state of emergency. I was retained to represent the Attorney General in every single state of emergency, from pre-action to trial. And I checked last week, and the state has not paid 1 cent in damages. Not 1 cent in damages arising out of the state of emergency.
can wrap up. You can wrap up. You can wrap up. After you smoke, you can wrap up.
Would you all like that I suspend for 5 minutes so that there can be order? I have made it very clear. Let us listen. Please let Senator Ramdeen make his contribution. All other members are to remain silent. All other members. Government, opposition, independent. Please continue, Senator Ramdeen.
Thank you, Madam President. Madam President, not infrequently, I have heard the Honorable Attorney General make reference to the fact that when the PNM opposition, they supported 95% of legislation that was proposed by the People's Partnership. And that, he says, demonstrated that they were a responsible opposition. Such support by the then opposition, Madam President, simply does one thing. It evidences the quality of law that was passed by the People's Partnership that was supported by the government, by the opposition at that time. We, however, on this side, as the opposition, understand the role of a responsible opposition, Madam President, and it is a bit different from that described by the Honorable Attorney General. References have been made over and over that what transpired between 2010 and 2015, and references have been made for a number of documents by the Honorable Attorney General. Madam President, I think it is only a matter of fundamental fairness that if the Attorney General is going to refer to documents and information contained in documents, at the very minimum, we are required to actually see those documents so that the reports that are being referred to by the Attorney General and the statements that are being put on the Hansard, at least we can confirm whether that is actually so and whether that is contained in those documents. Yeah. So at this point, I would ask or request humbly on behalf of the opposition that whatever documents the Honorable Attorney General is referring to, that he alleges certain things were said and certain things were done, and that was the basis for decisions made by the People's Partnership government when they were in power. If he could be so kind to just supply the opposition and the independent senators as well, so that we can all see what was there, we can all judge for ourselves, and we can all contribute in an intelligent way to this debate. It is not a rule, the success of which will be judged by us, ma'am, by the percentage of litigation. The success of us as an opposition is not going to be judged by the percentage of litigation we support that the government brings to this House. Legislation. We understand our role and our duty as a responsible opposition to act in the best interest of the people of Trinidad and Tobago. And that role, Madam President, to act in the best interest of the people of Trinidad and Tobago is not one that is confined to the people that have put us here. It is all of the people of Trinidad and Tobago. A concept that is very strange to the present government. As a constitutionally entrenched part of the legislative process, we as an opposition understand our role to support legislation that is brought by the government, that strikes the right balance between the citizen and the state and promotes the social contract that our democracy is based upon. But we will not support legislation that gives an unfair advantage to either the citizen or the state. Yeah. And we collectively, as a parliament, ought to understand that it is our collective role to put aside our political affiliations and act in the best interest of the state when legislation of this nature is proposed by the government. Where legislation is proposed, we will identify to the government where that legislation does not pass the test of constitutionality. And I can indicate, the Attorney General has indicated that in the other place, no suggestions were made. Well, Madam President, that is not so. A number of points were raised by the opposition with respect to the weaknesses that were inherent in the principal legislation and that were inherent in the amendments. And the government chose not to take it on board. So, we not being satisfied with that, we have traversed the Commonwealth jurisprudence of every single country where legislation of this nature has been enacted. And we have proposed a number of amendments that will strengthen this legislation if the government chooses to act upon it. And if the government chooses not to act upon it, they cannot rely on this opposition for that support. The legislation that is before us today, Madam President, has far-reaching consequences, legally and politically. And I regret to say that having heard the way in which this legislation has been piloted here by the Honorable Attorney General, it is clear that the implications and the consequences that can be put upon our people by this type of legislation has not been taken on board by the government. The consequences of passing this legislation in its current form can be catastrophic for our democracy and the entrenched freedoms that we, as a sovereign democratic state that is Trinidad and Tobago, enjoy and have enjoyed since 1962. I have looked carefully, Madam President, at what is proposed in the amended bill, and I have looked carefully at the intertwining of the legislation that is affected by this amendment. And I can say that this legislation, if it is passed in its current form, has the potential to infringe the right to liberty, the right to the security of the person, those rights having been declared and guaranteed under Section 4A of our Constitution, the right of the individual to equality before the law, and more so the protection of the law. And I will explain why. The right of the individual to respect for his private and family life, the right to join political parties and to express political views, the right to freedom of thought and expression, the right to freedom of association and assembly, the right to freedom of the press, and very, very importantly, Madam President, the right of each citizen of this country who are guaranteed the rights under Section 4 and 5 of our Constitution, not to deprive a person of such procedural provisions as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. Madam President, the situation that we as a Parliament or we as a Senate are faced with today, we are lucky that there is jurisprudence arising out of our jurisdiction number of years ago. And perhaps if I go straight to it and I refer to the very infamous decision of the Judicial Committee of the Privy Council in the matter of Thomas and the Attorney General, which is to be found at 1982 appeal cases at 113. And Madam President, allow me to quote what was said then in a situation where at the time that Lord Diplock was delivering this speech for the board, perhaps may have foreseen that a constitutional democracy such as Trinidad and Tobago would be faced with legislation similar to what we are faced with today. And Madam President, may I say that the words of Lord Diplock, as he then, Lord Diplock in 1983, are very prophetic to what we are faced with today. And this is what he said. Under a party system of government, such as exists in Trinidad and Tobago, and was expected to exist after independence in other Commonwealth countries whose constitutions follow the Westminster model, dismissal at pleasure would make it possible to operate what in the United States at one time became known as the spoils system upon a change of government. And this I wish to emphasize, Madam President, and would enable a government composed of leaders of a political party that happened to be in power to dismiss all members of the public service who were not members of the ruling party and prepared to treat the proper performance of their public duties as subordinate to the furtherance of the political party's aims. And even more pointed to what we are faced with today, Madam President, he goes on, in the case of an armed police force with potentiality for harassment that such a force possesses, the power of summary dismissal opens up the prospect of converting it into what, in effect, might function as a private army of the political party that obtained a majority of seats in the last election. And in 1983, it was said, their lordships do not suggest that there is any likelihood of any of these extreme consequences of the existence of a legal right of summary dismissal without cause occurring in Trinidad and Tobago.
At that time.
But what has actually happened in some other countries suggests that the possibility of the occurrences was not too far-fetched to justify, Madam President, to justify the constitution makers in the 1960s making provision to eliminate any such risk in constitutions which follow the Westminster model. The whole purpose of Chapter 8, now Chapter 9 of the Constitution, which bears the rubric the public service, is to insulate members of the civil service, the teaching service, and the police service in Trinidad and Tobago from political interference exercised directly upon them by the government of the day. The means adopted for doing this was to vest in autonomous commissions, to the exclusion of any other person or authority, powers to make appointments to the relevant service, promotions and transfers within the service, and the power to remove and exercise disciplinary control over members of the service. So, Madam President, what the Privy Council was saying was that since independence, those that went to Marlborough House to negotiate the terms of our independence in 1962, and I checked up to this morning, Madam President, one of the persons that went to Marlborough House in 1962 was none other than Mr. Lionel Sukaran. To negotiate that to protect us, the citizens of this country, from political interference by what could be deemed a political police force, we were insulated by putting in place in our constitution independent service commissions. If it is that the bona fides of the government is really to stop crime, that they are truthful and genuine in their intentions behind this legislation, then the Attorney General in his reply will kindly indicate to the other members of this House why is it that what is being done here under the SSA Act cannot be done under the police service. Why what is being proposed in this legislation cannot be governed by one of the service commissions, so that we can be sure that there is independence, there is insulation from political interference. But as we indicated, Madam President, when one looks at what was the principal legislation, the SSA Act itself, and I apologize, Madam President. If one looks at the principal act itself, you will see that I can point out in the principal act itself, Madam President, how is it that this government, how is it that the Attorney General can come to this House, know of these cases, know what the jurisprudence in our jurisdiction is, and seek to expand the powers of the SSA and leave in, without touching in the principal legislation, that the functions of the agency, that is the SSA, shall be exercised by the director after consultation with the minister? How is it that the Attorney General can bring legislation and ask us to support that legislation and ask the independents to support legislation where the director of the SSA shall be subject to direction of the minister?
A politician?
How is it that we can say that we are properly safeguarding the rights of the citizens of this country when the director of the SSA, and I will go to the Interception of Communications Act and show the pitfalls in that legislation. And Madam President, let me say at the outset, if things were done wrong before, we are here to correct it. It matters not. It matters not whether it was done by the People's Partnership or whether it was done by the PNM. We are here to do what is right and what is proper now. So it is no excuse to go back to the record of the People's Partnership or the PNM. A responsible parliament will do what is right for the people of Trinidad and Tobago. If we as parliamentarians abide by the oath that I took today, there can be no other outcome to this legislation than to either withdraw it or go with the amendments that have been proposed by the opposition. And I am sure the suggestions that will be proposed by the independents as well. But this legislation cannot stand in the form that it is now. Madam President, a lot has been made, and your ears might be tired of hearing the word proportionality and the word constitutionality. And I will take you, Madam President, and the other members of this House and demonstrate to you why it is that this legislation, in the form that it is in now and as it is proposed, will infringe the rights that are guaranteed to the citizens of this country. And in doing so, Madam President, if you would just allow me to take you to the Interception of Communications Act. And if we can go to Section 5, and I will take you, Madam President, through it step by step. Under Section 5, which is the interpretation section, an authorized officer means the Chief of Defense Staff, the Commissioner of Police, or the Director of the SSA. And before leaving the interpretation section, Madam President, intercept, which is the power that is given to these three officers as authorized officers under the Act, is defined as, in relation to communication, means listening to, monitoring, viewing, reading or recording by any means such a communication in its passage over a telecommunications network without the knowledge of the person making or receiving the communication, without the knowledge. And Madam President, it may have been an error, it may have been an oversight, but it is clear that Section 6, notwithstanding that this legislation was passed with a special majority under Section 13 of the Constitution, ought not or will not pass the test of constitutionality of legislation that would pass the Section 13 test of being legislation that is reasonably justifiable in a democratic state. And Section 6, Madam President, under the heading, Part 2, under the heading of Interception of Communication, provides that notwithstanding any other law, a person does not commit an offense, and that offense is under 6.1, which is that a person who intentionally intercepts a communication in the course of its transmission by means of a telecommunications network commits an offense and is liable on summary conviction to a fine of $500,000 and to imprisonment for 7 years. So 6.1 creates the offense. And when you go to 6.2, you have what I wish to emphasize is that 6.2 is not caught or engaged in the offense in 6.1 if the communication is intercepted by an authorized officer. And an authorized officer, as we indicated, is the head of the Defense Force, the Commissioner of Police, and the head of the SSA. Director of the SSA. And the communication is intercepted by an authorized officer, 1, in the interest of national security, 2, for the prevention or detection of an offense for which the penalty on conviction is imprisonment for 10 years or more, and includes an offense where death, imprisonment for the remainder of a person's natural life, or life imprisonment is the penalty fixed by law, for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provisions of any international mutual assistance agreement. Now, Madam President, those 4 clauses sound very laudable and sounds as though it provides a proper constitutional threshold for the exercise of that power. But the pitfall in the legislation, Madam President, is that what is not said is that when one of the authorized officers goes to execute or goes to intercept a communication under Section 6, there is absolutely no judicial intervention. It is interception at the discretion of the authorized officer. And it is because there is no judicial safeguard in the application of Section 6 that Section 6 will not pass that test of constitutionality. And if one wants to be generous, Madam President, we can understand why the head of the Defence Force or the Commissioner of Police the Parliament thought it necessary to give those powers to those persons because they are subject to a service commission. But it falls far short, Madam President, to allow a politically appointed person as the director of the SSA to have that kind of draconian power for this type of legislation. One must not easily forget, Madam President, that what transpires in the way in which director of the SSA is appointed now is that it is a cabinet appointment under Section 80 of the Constitution, and it is not one that falls within the exceptions for the President to exercise his discretion. So whoever it is that the cabinet appoints as the head of the SSA either appoints or chooses to dismiss, the President has no discretion. So whoever the cabinet appoints, they will be appointed. Whoever the cabinet chooses to dismiss, they will be dismissed, as has been the recent experience with the SSA. And Madam President, it baffles me to stand here and contribute to this debate. So short thereafter, people who were employed in the SSA have been fired at the discretion of the political directorate, and the statements that have been made in the public domain as to why Carlton Denny was fired from the SSA. Why he was fired? Because he didn't participate in ethnic cleansing of the SSA.
Senator Ramdeen, please. You're making a maiden contribution, and the convention and the practices that someone doing that is allowed to make his maiden contribution without interruption. But the person who is making the maiden contribution must also not be provocative. So please, in this Parliament, in this chamber, please withdraw any reference to ethnic cleansing, any sort of reference. Withdraw it and please move on.
Madam President, I withdraw it. I think what was said.
Let's not go over what was said. Just withdraw any reference, apologize, and move on.
I apologize to you, Madam President.
Thank you.
I think what is clear, Madam President, is that the fears that were indicated back in 1983 have come to pass with respect to the experience of any agency. A number of agencies have been in the contributions that have been done thus far have been identified as possessing this kind of power and this kind of discretion. And what the fears that were indicated by Lord Diplock in 1983 have come to pass because it is clear on what is in the public domain that what we are fearful of, which is political interference in positions where persons have the power to infringe the fundamental rights of persons, have come to pass. Madam President, I don't understand how the Attorney General can read out from reports and indicate that the SSA was performing functions that it had no authority to do. The reports say that the SSA was engaged in anti-terrorism. Where did they get that power from? And instead of rectifying that position, instead of doing something about the illegality that has already been committed, what we are seeking to do is provide legal justification for an illegality that has already been committed. So let us not fix what went wrong. Let us provide legal justification for it by the amendment. Now, Madam President, if we go to the principal
Senator
act
Ramdeen,
itself,
you have 5 more minutes.
as you please, Madam. Madam President, in those 5 minutes, let me just deal with this issue about proportionality, because a lot has been said about proportionality, and The Attorney General has indicated, and I'm happy that the Attorney General indicated that he has Malone and Kennedy in his bundle of cases, and I trust that reference will be made in the reply to the learning by the European Court of Human Rights as to what constitutes an infringement on the right to privacy. Because I can indicate, Madam President, that agreeing with Senator Mahabir, we in this country, whether we lawyers or citizens, we have a right to privacy that is enshrined in Section 4C of the Constitution. Madam President, perhaps the government will do well if they not only read Surat, but they also read the decision of the Court of Appeal in Inch and Ishmael, a decision that was delivered by one who I consider one of our brightest judges in the Court of Appeal, Justice of Appeal Jamada, for whom I have the greatest respect, where he indicated, Madam President, and I cannot understand how a sitting Attorney General cannot bring this to the Senate, where we are deliberating the constitutionality of legislation, that right now in our jurisdiction, Madam President, the state of the law is uncertain because there are two schools of thought with respect to proportionality. There is a school of thought that applies in our Constitution that arises out of the infamous Hines from Jamaica, which says that any right, any legislation that touches a fundamental right must be passed by a special majority. And then there is the learning in Surat. And if the Attorney General were to read the decision of Justice of Appeal Jamada in Inch and Ishmael, you would see where Justice of Appeal Jamada says that there is a collision between what we consider to be the correct test. That didn't go to the Privy Council. So, Madam President, in wrapping up, Madam President, I would like to say this in closing. We all have a responsibility to those who have gone before us, those who are here with us today, and those that will be our future. Let us not be remembered as a parliament who stood up for what was right, when we could easily. Let us be remembered as a parliament who stood up for what was right when we could so easily have given into what was wrong, so that our children and our grandchildren would look back upon us and be proud of the decision we make when we are called upon to vote on this legislation. Let us abide by the oath we all took. The choice is ours. We as a democracy are 54 years old. We recognize in our Constitution that we are a sovereign democratic state. We recognize in the preamble to our Constitution that men and institutions remain free only when freedom is founded on the respect for moral and spiritual values and the rule of law. We are going to sacrifice all that we and our forefathers, yours and mine, have worked so hard for in the interest of selfish political gain? Is it really worth it? Are we going to support this legislation that has the potential to undermine the freedoms that we all enjoy as a people, as Trinidadians and Trinbagonians? Madam President, with the most generosity afforded to the government, it would be a breach of the oath that I have taken today to support legislation in its current form, and with all good conscience, I cannot. Thank you for allowing me the opportunity, Madam.
Before we move on to the next speaker, may I congratulate Senator Ramdeen on his maiden contribution. Senator Roach.
Thank you, Madam President, for the opportunity. I'd also like to congratulate Senator Ramdeen on his maiden contribution this afternoon. Madam President, much has been said this afternoon to awaken one's anxiety to see where it will end. But let me comment my contribution, first of all, on a positive note, one that is encouraging. I'm proud to say that, and I'm sure those who are concerned will also be proud to say that for the first time as a senator, I received a package from the opposition leader, Kamala Prasad Bisasa, SC MP for Superior, which to me was diligent and purposeful in providing me with her contribution and that of the Attorney General's contribution, along with 4 other enclosures. Now, I have not conferred with any of my independent senator colleagues to know whether or not they received such a package as well, but I want to believe that they did. And it provided a lot of food for thought for me in terms of understanding the opposition's position where this legislation is concerned. And like the learned Attorney General here this afternoon, he also indicated that he also made certain materials available to Parliament, track changes and so forth, which have assisted us in our deliberations and preparations, and I thank both for that. But as important as this debate is, Madam President, and it concerns certainly all citizens listening on this debate, the bill is not a voluminous bill. It is not a complicated one, requiring grave hours of deliberation. I say so with great respect to those who have spoken and those yet to speak. However, having said that, therefore, I will try to, my intention is to keep my contribution as brief as possible and to the point. As indicated, time and time again by various senators here, that the bill consists of basically 5 clauses, 3 clauses which are seeking to amend Clause 2, 6, and 9 of the Strategic Services Agency Act, Chapter 1506 of the laws of Trinidad and Tobago. The Attorney General here indicated that it touches and affects about 11, he said, pieces of legislation. He listed them out: the Constitution, the Proceeds of Crime Act, the Traffic of Persons Act, the Interpretation of Communications Act, the Financial Intelligence Unit Act, the Dangerous Drug Act, the Anti-Terrorism Act, the Firearms Act, the Police Service Act, the Defense Act, and he said the Computer Misuse Act, which I believe is yet to be born. Is the old one, right? Now, the genesis of this, as you have heard again throughout the deliberations and contributions of the senators, is that the Strategic Agency Act came in 1995. It came specifically to deal with the influence of drugs in detecting and certainly principally in meeting our treaty obligations to the United Nations. And it afforded our agency, our local intelligence agencies, I guess, a certain power or latitude in assisting in the detection and the curtailing of the rampant scourge of the drug trade. But as we know, the drug trade is a morass of criminal activities. It is complicated, it is complex, and it is far-reaching. The use of technology in today's world has facilitated crime across borders almost with impunity. As far as you pass laws, they are not, in most instances, able to keep abreast with the changing and configurations and morphing of the criminal activities. They are almost sometimes seem to be a step ahead. There's a lot of concerns, and of course, there is suspicion on the part of those on the opposite side concerning the objective of the government passing this bit of legislation, which seems to be draconian in nature. But, Madam President, let me hasten to say this. Where you have a grave situation, where you have a drastic situation as the scourge of seem to be a runaway horse of crime in our country, is almost a pandemic. Drastic measures are necessary sometimes so as to bring back some sort of evenness into it. Yes, the liberty of citizens are always and must always be foremost in those of the legislators and those who see about in passing and protecting the very citizens that where liberty could be not trampled upon is to be very careful, to do so with caution. This bill, to me, seems to expand the capacity of the SAA initial remit, which was the gathering of intelligence specifically for drug-related matters. it has been amended by adding serious crimes, which has been elucidated here and listed in, I think, is it section 6 of the Act. And what I understand the agency to be charged with is the collection of intelligence. I read somewhere, I think in one of the contributions, or when the literature was given, that there are some total of 19, for want of a better description, spy agencies or spy units in Trinidad and Tobago. That's quite a bit for a small country such as Trinidad and Tobago, with a police force of probably what, I think at this point in time it could be 7,000 or 5,000. We have the defense force, we have the customs. So and they've been listed. I don't want to take up too much time in listing all of them, but they are quite significant. Much of some of them I was very surprised to know of them. The Custom Excise Enforcement and Operation Unit, the Defense Force Intelligence Unit, the Financial Intelligence Unit, the Finance Intelligence Branch, a division of the Trinidad and Tobago Police Service, the Integrated Threat Assessment Center, the Ministry of Foreign Affairs and CARICOM Affairs, the National Coastal Radar Surveillance Center, Anti-Kidnapping Unit, the Crime and Gang Intelligence Unit, Criminal Investigation Division, Homicide Bureau, Cyber Unit, Special Branch, Fraud Squad, Organized Crime, Narcotics, Firearm Bureau, Prison Service Intelligence Unit, Counter Trafficking Unit, and the Immigration Investigation Section. Madam President, that is significant a number of intelligence agencies. And what I gather is that there is no synergy, there is no smooth interrelations between them in terms of passing and using their information or sharing their information towards a productive end, which is either preventing crime, detecting crime, and leading to the successful prosecution of crime. One of the senators here, I'm not sure which one it is, that said that, in terms of giving the SAA more powers when they could not have fulfilled with a certain amount of success or any success at all, their mandate was limited in terms of drug surveillance. How can they be trusted in dealing with this expansive power? Now, because our criminal justice system is one that is not unique to us, but is a typical criminal justice system that you will find in any developed country, which is the police, the judiciary, you have the prison, you have the DPP, and in all of them, what supplies, what assists and promotes that is intelligence at all levels. We will know how important intelligence is going back to 9/11 in the United States of America. America is a country that spends billions of dollars annually on their intelligence gathering and sophistication in keeping abreast with the times and so to prevent the security of their citizens. And notwithstanding the billions of dollars that were spent in terms of intelligence, yet still 9/11 happened, unfortunately. It changed the course of how everything went on in the world thereafter. It changed the way people travel, it changed the way people communicate and everything like that. And certainly there was some, what caused examination, I think they had hearings, and there were some flaws, notwithstanding the amount of money that was spent in it. But that did not deter them from taking some more stringent measures in terms of trying to fill gaps or close gaps in their intelligence gathering and so forth. Because what intelligence does in a security system is to be most useful is when it's preemptive, when it can prevent, as opposed at the other end when it already happens. And as much as there are flaws, and there must be concerns about the powers that is being given to the SAA as an agency, as wide as it is under the definition of Section 6, still one has to weigh, as Senator Ramdeen was talking about, proportionality, and all lawyers will talk about proportionality. Legislators here that will understand proportionality, but at sometimes the freedom of the citizen must be put. It cannot be absolute. It certainly cannot be absolute. And the fact that it's not absolute and it means that something has to be given up in order to achieve some other end. In this particular instance, one has to determine whether or not what is being sought to be done in terms of securing and making the agency of collecting the type of information will be necessary to filter down the whole criminal justice system is one that is adequate and sufficiently equipped to do so. But I guess the concerns of all present here and listening is if this is in fact going to be as draconian as it's being made out to sound by some commentators, what are the checks and balances that is being offered to keep a sort of an eye on it? And there are a number of other concerns which were raised by the opposition. And it has to do with the appointment of the directorship. It has to do with the funding of the agency. It has to do with the staffing of the agency. It has to do with the collection of the data and type of data being collected by agency. And it has to do with at the end of the day, the supervision of the work of the agency. The ability for them to have easy access to invade people's private communications and so forth. But we know that without giving the necessary agencies the necessary power to be able to do those things, we allow ourselves to be exposed to the very same thing that we all are fear, which is the commission of crime at some point in time in some form against us or our families and friends. And therefore, I am very much willing to support this legislation on the basis that there are certain concerns that were raised by the opposition, some of which are not whimsical, and I think ought to be looked at carefully by the government and considered. And it is probably important to also say that, we're making a lot of fuss about the appointment of the director of the agency, which is an important appointment because he will be charged with a lot of responsibility in determining, as one of the authorized officers, in determining when and who could be tapped for whatever purposes. Let it be known that in the United States, the CIA director is appointed by the president, yes, by the supervision of by Congress, by the Senate. In South Africa, from which I'm very familiar with, the director of the two agencies are appointed by the president. And they are not public servants. They are contract workers, basically. However, you have a joint select committee on intelligence that supervises and deals with the operations of the agency as a monitoring oversight committee. And you have an inspectorate of intelligence. And that is South Africa's model for their checks and balances in their intelligence agencies. And of course, they had a number of agencies prior to the ending of apartheid and since post-apartheid. And they have consolidated over the years through the different number of intelligence acts, 2009, 2011, I think. So most recently, probably 2012, I'm not sure. But I'm saying this to say that the appointment, if in our community, in our society, we are that uncomfortable with the executive having the sole discretion of appointing the director of an agency of such, probably we can find a compromise that may rest comfortably among all concerned. Because to me, Madam President, what I find amazing is that when members sit on the opposition, members of the opposition that come and go, when they are here, they have 20/20 vision. Madam President, they see all things, they know all things, they have the remedies for all the ills of our society, right? But something strangely happens, Madam, when you become government sometimes. Amnesia set in, cataract set in, hearing sometimes disappear, the rumblings of the public become muted. And to me, wherever it is in Trinidad and Tobago right now, over the last, since 1985, I think, or 1985, there's been a constant revolving of governments in for one term rather than 2 terms and 3 terms of time immemorial that used to exist before for expansive years. And it's quite easy to make laws bearing in mind that I will not always be on this side. These sides are changed very quickly and within 5 years. You know, you have the public, the discerning public, who is restless and I think is losing patience quite quickly with governments that not meeting up to their expectations. And therefore, their threshold for tolerating inefficiencies, dishonesty, and so forth is quite low, and as we have seen. Having said that, Madam President, therefore, if it is that we are all here, and what I mean hearing from all the senators so far, they are not saying that the law is not to be passed, that is not a law that is not required. They have concerns of how it's going to be used, how it's going to be monitored, and so forth. And therefore, I think this can be addressed through proper, open, frank discussions in debate, or if it is necessary, that debate is not sufficing the needs of those who need to vote on it. Probably a joint select committee, being referred to a joint select committee, it may not be a bad thing. May not be a bad thing. But it is quite evident to me that there is a distrust on the part of the opposition for what is being promoted or being projected by the government in terms of the aims and the main aims and objective of this bill passing. I believe it is a bill that is, I believe it is a requirement that is necessary. We need to empower our agencies. We need to have proper checks and balances in the power that we give them. And if it is in Trinidad, we are a unique society, I keep saying all the time. We probably can fashion something that can meet our peculiar circumstances. Why not? South Africa has done it in the way in which they have done it. They haven't copied the American system. They haven't copied the English system. We can probably fashion one, engineer one that is suitable to us, that we are comfortable with. So probably for, in the appointment of the director, probably on consultation with the leader of the opposition and the Prime Minister as a midway, at least, right? In terms of the Joint Select Committee, yes, I do not think that the annual report being laid in Parliament is sufficient. I do not think because of the timeliness, always behind time in being inappropriate. I also think that the scrutiny of the Auditor General also a bit tardy in terms of just volume for whatever reason, could be lack of staff, whatever it is. And therefore, Joint Select Committee under, I think, if we stand in order for Senate is 102. I think if these standing Joint Select Committees can be given more coercive powers of sanction, that it could be powers of sanctions as well. Yeah. Could go a long way in sort of alleviating some of the concerns and the anxiety of members, right? And of the public as well, because of course nobody wants to be on the wrong end of the intrusion on their privacy. As I said before, in the other parliament, if I can recollect, in one of my contributions, I did speak about persons coming to me, friends and other persons, and they would take out their batteries from their phone, leave it in the car, some of them not. This was not the government in power this time. So obviously, people know what they're talking about in this country, right? I spoke about that in the 10th Parliament, this is the 11th Parliament, and now this bill has come up here, and I think it is a concern that is a real concern, So having the judicial supervision is also very important. It is provided for according to the Attorney General, which I have seen in the ICA, right? And the question of whether there's a loophole in terms of being able to intercept without judicial scrutiny or permission first, I am not sure if that is tightly taken, that is taken care of completely. But you have, in terms of emergency, which will arise, you can't always go to court to get what you need if something is happening momentarily, the urgency of the matter. But what it does stipulate is within 96 hours, I think, 92 hours thereafter, after you have given, the judge has given oral hearing and probably authorization, you must, section 11, you must supply the written application thereafter, and he can either revoke it or confirm it or extend it as the case may be. So we can look at all these provisions to see whether or not they are in fact tight enough. But judicial supervision is something that is necessary and cannot be easily, should not easily be shunned at all. It is always the protector of the citizens' rights and freedoms. One of the other concerns I think was raised, is the heading of the same judicial legal, the Joint Select Committee. I do agree, and I will advocate that the Joint Select Committee dealing with intelligence or national security should not be headed by a government person. It should be headed by either by an opposition member or an independent member of the bench, just to give that level of objectivity and control. Oversight. I think it leads more to confidence than anything else. And as I said earlier on, if we are to treat with each other, exchanging ourselves in each other's places, I guess you will do the right thing much more often than you will tend to do the wrong thing or do things that will unearth suspicion unnecessarily so. Madam President, as I said, there are a number of different things we can go on and on talking about the constitutionality. We can pick at the at some of the shortcomings of this legislation, but it's nothing that is not curable. It is not. It's not an act. It's not a bill. I think that should frighten anyone that is hearing of it. I mean, we in here have different rules to play in terms of how we approach our tasks. But at the end, as Senator Ramdeen said, we all should be on the same page in terms of doing what is best for the public, for Trinidad and Tobago. I believe that the government indicates that they have as the Attorney General said, he has an open here. This is not a closed session. He just come here to run through this debate. He's open to suggestions that are constructive, that may assist in making the law a robust, effective, and one that is reasonable and proportionate in its nature. So, Madam President, as I said, I do not want to detain this chamber going over and traversing what has been highlighted by my other colleagues very cogently in many instances, in this instance, and informative. And therefore, I will trust that the Learned Attorney General, in his wrapping up, will address some of the issues that were raised by all members, and where possible, seek to make the necessary amendments so that we will have a bill that can really be for the benefit of the people of Trinidad and Tobago. Madam, with that, I say thank you.
Minister of Agriculture.
Madam President, thank you for the opportunity to join this debate on the Strategic Services Agency Amendment Bill 2016. Madam President, in this House 5 years ago, to the date, Tuesday, May 3rd, 2011, the then Minister of National Security, John Sandy, stood to answer a question posed to him by then Senator Fitzgerald Hines. And that, to me, both the question and the answer sets the context of this debate on the Strategic Services Agency Amendment Bill. And you know, in this country, we have a way of saying, somebody take in front. I recognize that Senator Ramdeen took in front. by removing himself and his party from involvement in anything prior to today, giving his party a clean sheet. And this year the PNM celebrates its 60th anniversary, Madam President. And what distinguishes this party from every other party before us is that we are prepared to defend our 60 years, whether in government or in opposition. We don't pick and choose the parts that are favorable to us and pretend that the unfavorable parts do not exist.
Just don't exist.
And today, Mr. Ramdeen, in his maiden appearance, Senator Ramdeen, will not be given the pleasure of having the record of the UNC erased. So on Tuesday, May 3rd, 2011, Senator Hines had asked then Senator John Sandy about the highest level of qualification of one Rishmi Usha Ramnarayan. Rishmi Ramnarayan, of course, Madam President, had been nominated by someone who remains unknown to a position that remains in doubt. It was never very clear if Rishmi Ramnarayan was nominated to head the SSA or the SIA. But one thing we are absolutely sure about, Rishmi Ramnarayan did not possess the very basic qualifications taken at its most basic level to head a strategic agency involved in anti-crime efforts in this country. That is something we are very clear about.
Selective amnesia.
In fact, Madam President, Rishmi's qualification in answer,
Selective amnesia.
then Senator John Sandy, in answer to Fitzgerald Hines' question, said that Rishmi possessed a Microsoft Certified Systems Engineer, MCSE certification. And Mr. Hines referred to a discussion in the other place at the time that Rishmi Ramnarayan was said to have possessed a university degree. And the then Senator John Sandy begged off the discussion, saying, I had already been in that place and I had apologized to the country for providing misleading information. And in the course of answering that question, John Sandy suggested that that misleading information regarding the qualifications came from no one but Rishmi Usha Ramnarayan. And so 5 years later, the UNC COP, whatever they call themselves, returned to this house. But on the other side, raising issues of qualifications and questioning matters of integrity and trustworthiness and so on, and wishing this country to forget what went before. But that is the context of this debate, Madam President. Because this is 5 years later, and more than 2,000 murders later. And I don't intend to list all the criminal offenses since that day, 5 years ago. And if it's anybody, any organization that has led to the level of distrust Senator Roach says exists, and the total failure of the national security apparatus in this country, it's the UNC. For having the temerity to foist on this country someone as unqualified as Rishmi Usha Ramnarayan to head a significant agency in the national security apparatus of this country. Let me start that way, Madam President.
That's like not putting your opinion in writing.
And then Senator Mark comes here today. And there are references to the NOC, National Operations Center. And right away I remembered, Madam President, the debates over SORT, the Special Anti-Crime Unit of Trinidad and Tobago. And I, in my life as a newspaper columnist, also raised over the years concerns about SORT. But the persistent argument against SORT was that SORT was not created by legislation, and it lacked the sort of oversight that was required on a series of arguments. And the same people who fought SORT got into government, and by cabinet note empowered the NOC to do exactly what SORT was doing. The same people empowered NOC to do everything, including what the SIA and the SSA and everybody else was set up to do. And that same group, Madam President, returned today to question this government's decision to deal with the SSA, not by cabinet note, but by legislation brought openly to this Parliament for full debate. An administration that for 5 years is prepared to allow the national security apparatus in this country to be governed by a cabinet note by the very same politicians they accuse today of wanting to tamper with national security. And Madam President, it was never lost on me the day when the NOC was put under the complete control of the Office of the Prime Minister. And the choppers and the surveillance system. And in this case, not the Israeli equipment that they complained about under SORT, but the Chinese equipment. All put under the Office of the Prime Minister, together with, of course, full procurement responsibility.
Billions.
And of course, Senator Ramdeen, in his maiden speech, excises the 5-year period, May 2010 to September 2015, and refers to the Auditor General and criticizes the Auditor General in the period before. Forgetting life sport. And the special audit into the School Nutrition Company Limited.
And the ITU.
And the special audit into police vehicles.
All of which being acted upon.
And putting blame at the feet of an independent officer, independent constitutional office, and expressing distrust in that constitutional office. Because unlike the people on this side, Senator Ramdeen is part of an organization that has given unto themselves the luxury of selecting the parts of their political life they wish to select. And Senator Mark has done the same, putting forward NOC and criticizing this process by which legislation is being brought to deal with the SSA.
Selective amnesia.
And of course, Senator Mark again refers to the absence of regulations in the 21 years of the SSA, conveniently forgetting that for 11 of those 21 years, the UNC was in government. And if anybody has failed this country in failing to bring regulations for the SSA, it's on both sides of the house, and that is why we are here today.
I am bringing them. That's why they have a proclamation clause in there.
And then Senator Mark talks about
Bringing a lot more. Wait and see.
the appointment of a deputy director of the SSA, and specifically refers to the recent appointment reported in the media of Anne-Marie Daly as deputy director of the SSA. And in fact, Senator Mark goes so far as to say Daly's appointment, recent appointment as deputy director, may even be an illegality because the position of deputy director of the SSA does not exist. And Senator Mark, being a UNC, has that luxury. Because, Madam President, 5 years ago, on this day, Tuesday, May 3rd, 2011, then Senator John Sandy, responding to then Senator Fitzgerald Hines on the question of Reshmi Usha Ramnarayan's appointment, was asked about the nomination of Ms. Ramnarayan. And John Sandy answered, the nomination came from the deputy director of the SSA. 5 years ago. 5 years ago, under UNC administration, there was a deputy director of the SSA,
I have it in writing.
real enough to make a nomination of Ms. Ramnarayan and have it accepted.
Selective amnesia.
And 5 years later to the date,
And it's legal under Section 5.
Senator Mark talks about illegality and the non-existence of that position.
It's a stranger to the truth.
Of course, Senator Ramdeen talks about the Joint Select Committee and says, well, you know, anytime a national security question is asked, they would say in response, it's protected as a national security issue. And he has the luxury of saying that. Because when asked by Senator Hines about the identity of the deputy director of the SSA who nominated Reshmi Ramnarayan, then Senator John Sandy took the exact position. He said, it's a national security matter, and you should know that I can't disclose the identity of the deputy director of the SSA. And so today, Madam President, we've been fed the usual fear from the other side.
Selective amnesia.
Fear-mongering, arbitrary imprisonment, spying, privacy invasion from an opposition that has absolutely no moral authority on anything related to the SSA. This is simple legislation. Simple legislation, Madam President. This legislation seeks to do 4 things. The first thing, it seeks to expand the remit of the SSA. And that is obvious. In 1995, in Trinidad and anywhere else in the world, the trade in narcotics would have been a big issue. In 1995, we weren't talking about terrorism and money laundering to the extent that it is a problem now. We surely would not have been talking about human trafficking. For all of us, our forefathers who trafficked to this part of the world, we would not have been talking about that. But 21 years later, drug trafficking and the narcotics trade is one of the major issues facing the country in relation to crime. And the expansion of this remit of the SSA, Madam President, is to capture all those serious offenses. The alternative, of course, is to create an agency to deal with human trafficking, and one to deal with terrorism, and yet another one to deal with money laundering, and to create a series of agencies. That is the alternative. And all this bill seeks to do in the first instance is to expand the role of the SSA. And the fact that the SSA, to get to Senator Mahabir's point, we've not had the level of prosecutions in relation to major drug hauls, but surely that could not lie solely at the feet of the SSA. Experience has shown us that the failure in this country to prosecute to the extent that the citizens of this country would like is a failure that runs throughout the judicial system. It's not one agency. This bill seeks to deal with one agency today. The Attorney General, I'm sure, will bring to this Parliament legislation to deal with all the other aspects of the judicial system. The second thing, the legislation, the second part of the expansion is that this expansion will give the government an opportunity to remove duplication, to remove the overlaps and the proliferation of various agencies and entities in the country performing the same exercise. And the rationale for doing that, Madam President, is not only because resources have gotten scarcer. It's just simply the human resource to staff various agencies which proliferate does not exist in this country. And what we need is a single agency, fully resourced and focusing on the serious crimes which have been identified in the bill. The second thing about the bill, Madam President, is that it seeks to empower the SSA. And that is obvious. Now that the remit has been expanded, empowering the SSA is a consequence of that expansion. The entity must be given the powers over those serious offenses and other offenses for which the term of imprisonment is more than 5 years. But thirdly, Madam President, and this is something that Senator Roach pointed to, and maybe others, this amendment bill seeks to restore some balance. Because there's no question, Madam President, in any country, a population of 1.3 million, where we've averaged more than 350 murders a year, in any country, those statistics demonstrate that the balance of power is in the hands of the criminals. And what do we do in the face of that? Pontificate like academics on the issue of fundamental rights, or attempt to restore the balance and give the country's national security apparatus an opportunity, an advantage, a chance to restore the balance in favor of the citizens of this country. And this issue of restoring the balance is not new. In fact, it is interesting that Senator Mark referred to the Interception of Communications Act and the debate, and Senator Ramdeen referred to the same piece of legislation, of course distancing himself from it this time around. But it was the former Attorney General, then Senator Anand Ramlogan, in that debate on the anti-gang bill that talked about restoring balance. But he didn't say restoring balance. He talked about clawing our way back into a constitutional position where the rights of the citizens would be balanced with all the other considerations, always putting national security as a priority interest. And of course, in the debate on that anti-gang bill, as it turns out, Madam President, every speaker on the other side supplied the data to demonstrate how well the government at the time was doing on crime. Every speaker. Murders were down and they were doing well. Very hopeful of reversing this trend of crime. And of course, history would show 3 months after, the same government had to resort to state of emergency to deal with crime. And all that has happened, it does not matter who is defending whom and who appeared for whom in which court. All that matters is that young black men in this country, targeted because of wearing vests and three-quarter jeans, were rounded up, Madam President, under this anti-gang legislation and dragged before the courts. Not one prosecution being successful. 3 months after this last administration came to the parliament with anti-gang legislation and boasted about how well they were doing on crime. So when we talk about distrust and lack of integrity and concern about the excessive hand of government, we don't have to go further than the state of emergency imposed on a particular demographic in this country by these gentlemen who are now in opposition. We don't have to go very far. And going back to Senator Ramdeen and his contribution. As I say, in this country we have an expression called taking in front. And Senator Ramdeen knows why. He's well read. And unless I'm wrong, Madam President, and correct me if I am, he practiced in the chambers of the former Attorney General, Mr. Ram Logan. Perhaps he's still practicing with him. But on that communications bill debate, Madam President, Tuesday, 30th October 2010, this issue of safeguard came up. But of course, Madam President, the UNC in government had the luxury of working with a PNM in opposition. And it is a matter of record, Madam President. PNM has demonstrated that almost on every occasion it has cooperated with the UNC in government, particularly on matters relating to crime. So that when the issue of safeguard came up on that piece of legislation, it is then Senator Anand Ram Logan who talked about these 3 officers that Senator Ramdeen referred to. And he talked about those 3 officers: Chief of Defense Staff, Commissioner of Police, and the Director of the SSA being part of the safeguard. That is the assurance he gave then to this country, that these officers, being independent, represented the safeguard that the country needed. In fact, I was surprised to hear Senator Ramdeen talk about the appointment of the Director of the Strategic Services Agency in terms of a political appointment, because it is the then Senator Ram Logan who said to the Parliament, the Director of the Strategic Services Agency is appointed under Section 4 of the SSA Act by the President for a term not exceeding 5 years and is eligible for reappointment. And then he says, that forms the first safeguard for the citizens of this country.
Say it again.
And 5 years later, from that side, the director of the SSA is put in a different light. A political appointee, subject to the whims and fancy of the minister. And as they like to say about the PNM, a creeping dictatorship. And for all that time, 5 years in government, they sat and did absolutely nothing until now, and the PNM has to come back in office and continue where we left off in May 2010. And, Madam President, the discussion was the same on the warrant and the judicial intervention, and the same answers were offered, except that today, the answers are being offered by the PNM in government. Years after, we cooperated with the opposition in getting this legislation through. And there is another discussion, Madam President, on this issue of the additional offenses, what we now call the serious offenses. So as I've said before, the SSA legislation dealt with one category of offense, narcotics offenses. And this bill expands that to a range of offenses. So serious crime now includes homicide, treason, terrorist acts, terrorist financing, hijacking, kidnapping, trafficking in persons, trafficking in children, gangs, illicit trafficking in narcotic drugs, etc., etc. And Madam President, at least this bill lists the serious offenses. And towards the end of the definition, there's a sweep-up line which refers to any other offense. Any offense which carries a penalty of not less than 5 years imprisonment. And on that same interception of communication bill, the then Attorney General, then Senator Anand Ramlogan, was asked about the absence of a list of offenses to which the interception of communication bill would apply. And his response was that it is easier, it is simpler to simply say the bill would apply to those offenses that carry a term of imprisonment 5 years or more. That is what he said in the debate. And what was his rationale for saying that? What was the rationale? He offered the country. He says, unlike other countries, where you have a schedule, and you legislate by reference to the schedule, you have to keep coming back to the parliament to amend the schedule. And there are so many crimes that would be created in the future, you would have to keep coming back to parliament every time to amend the schedule. In fact, he says, when that happens, each time you would have to go back and amend the schedule to permit the interception of communication in the investigation of that new crime. And it made sense. And the PNM, in opposition, supported him fully. And this time, in this legislation, we are not giving the SSA expanded powers in relation to simply the prison term. We have set out specific offenses, and in addition to those offenses, those which carry a term of more than 5 years. And the rationale of the Attorney General must be the same as the rationale of then Senator Anand Ramlogan when he answered the question in November 2011, 2010, Madam President, in relation to the Interception of Communication Bill. Madam President, the fear-mongering and rumor-mongering and the concern supposedly for the citizens of this country should not prevent us from doing what is right. And doing what is right, Madam President, does not carry itself the luxury of standing on principle today and then reversing yourself tomorrow. That is a matter of convenience. On this side, we belong to a party that has been called upon time and time again in this country to defend a 60-year record, and we've always stood up to defend that record. Today, representing what we believe is right for this country and the citizens of this country. This is not an academic exercise. This country does not have the luxury of spending more and more time. We have to address the serious issues of crime. This piece of legislation is a step in the right direction, and for that reason it's been laid in this House. It's not brought in a capricious manner through the cabinet. And the SSA is not being moved under the office of the Prime Minister in a capricious manner. It's being dealt with in full view of the country, the way it shall be done. Thank you very much, Madam Speaker.
Senator Ameen.
Madam President, I thank you for this opportunity to contribute to this debate on the bill entitled An Act to Amend the Strategic Agencies Act, Chapter 1506, to expand the functions of the Strategic Services Agency. Madam President, let me begin by indicating that the opposition remains committed to supporting measures aimed at reducing crime in Trinidad and Tobago for the sake of all our citizens. Madam President, notwithstanding the shortcomings of the bill presented before us, it seems to me, Madam President, that although the tone has been set for a debate that will dwell on the situation at hand, it seems that there are some members of the opposition, and the way things go in these days, I'm not sure if ministers are speaking on behalf of the government or their own selves these days. But the contribution of Senator Clarence Rambharat, it is clear that there are some members of the government who wants to be stuck in this time warp. I heard mention of Reshmi Ramnarayan and the situation that occurred, a situation that was corrected immediately, well, within 2 days of it occurring. And I heard criticism after criticism with regards to the qualifications of Mrs. Ramnarayan. Today, Mrs. Ramnarayan is probably more qualified than Senator Clarence Rambharat himself now. But what I did not hear, Madam, what it makes very clear, Madam President, is that Senator Rambharat is in fact indicating the shortcomings of the Attorney General by not making recommendations to bring correction to this situation, which he has an opportunity to do now by laying this bill. So he has indeed, in fact, added his voice of criticism to this bill. We have not, this country, Madam President, is yet to hear a comprehensive plan to deal with crime and violence in the country, a plan that citizens can buy into. The citizens have not seen a strategic approach to dealing with law breaking in this country. We are in a situation now where members of the government even would point to the increase in violence, the increase in gang activity, the increase in the number of murders, and as of Saturday, it stood at 153, but I understand there were about 3 murders last night, so it's just below 160 at this moment. And the murder rate for this year, 2016, has surpassed the murder rate of previous years every other year in the history of Trinidad and Tobago under the People's National Movement. And we are yet to hear of concrete recommendations to move forward. There are 3 ministers in the Ministry of National Security, 1 minister and 2 ministers in the ministry, and yet there's a deafening silence. But there is no doubt that the concern and fear of the citizens of this country is being played upon by the present administration. And while it is very clear from reports going back several years, there's the Gibran report, the Ross report, and several others, and it appears that the government is agreeing that they see the need for a centralized intelligence gathering agency in Trinidad and Tobago. Madam President, if that is so, then the government is duty-bound to bring suitable, wholesome legislation to establish such an agency, to get the approval of Parliament, to engage the opposition and the independents, if it requires a 2/3 majority. But Madam, or 3/5, my apologies. But Madam President, this government and this Attorney General has failed in this measure and has brought before us really an insufficient piecemeal bill that will not do the job. Madam President, with greater responsibility, with greater power comes greater responsibility. This bill seeks to increase the responsibility of the Strategic Services Agency. We have seen increased power, increased responsibility, and what we on this side, and what I have heard from independents and those stakeholders in our society, is that it lacks measures for increased accountability and any measures for independent oversight, which is very critical. Madam President, intelligence services play an important role in protecting national security and in upholding the rule of law. Their main purpose is to collect, to analyze, and disseminate information that would assist policymakers, the law enforcement agencies, and other public entities in taking measures to protect national security. And this, Madam President, includes the protection of the population and their human rights. The mandate of an intelligent agency should be precisely and narrowly defined in whatever law that is coming before the Parliament. The mandates of an intelligent agency should be limited to protecting legitimate national security interests and must be clearly outlined. For instance, we spoke about, for instance, if terrorism is included, you must be clearly defined, you must narrow, you must be precise in terms of what you intend to target, and for what you will allow those rights to be violated. The powers and the competence of intelligence services are usually clearly and very explicitly defined in law. They are required to use these powers solely for the purpose for which they are given. And measures must be put in place to prevent abuse of any of these powers. In particular, any powers given to intelligence services for the purpose of counterterrorism must be used exclusively for that purpose. And while the amendments before us seek to expand the power of the SSA, I wish to ask this Senate that we, every one of us as individuals, have a responsibility to ensure that we utilize this Parliament to consider oversight mechanisms to ensure accountability in line with the power to be given. Accountability, Madam President, protects, at the end of the day, protects the citizen of this country. It protects the people. It protects the people from abuse of power. It is very easy to name the politician as the potential abuser of power, but there are circumstances which we may not conceive of right now that could arise, that we must always be mindful to protect our citizens from abuse of power, from arbitrary rule. The question is whether we want to allow the political directorate to have a say over intelligence gathering and, to an extent, law enforcement. And that measure, Madam President, if I could ask the senators on the other side to silently let your conscience be your guide. Flip the script and ask yourself, the powers that you are asking to be bestowed on the SSA in the present form with a political appointee as director, ask yourself if you would be comfortable with this method being implemented if you were not in government and any other political party were there. Would you be comfortable giving this same power to any other political party? And, Madam President, I want to submit that the legislation must be sturdy enough to withstand changes in the political environment and not leave room for any perversion from the original intent of passing these laws and the amendments that were brought by the Attorney General. Madam President, any law enforcement agency or intelligence gathering agency which is receptive to the political machinations of a government poses a danger to the fundamental human rights guaranteed in the Constitution and in our democracy. Political influence, whether it is direct or indirect, overt or implied, actual or perceived, regardless of the political party in power, is dangerous. And, Madam President, the appointee does not have to be a friend or close associate, but the mere fact that he knows that his appointment is due to a politician, or the fact that he knows that he could easily be fired by a politician without any spoken or direct instruction from the politician who appoints him, it is very likely that his actions will be influenced by the political affiliation of that person who appointed him. Madam President, and this is where I asked that we consider putting in measures for independent oversight. The recommendations brought forward by the Attorney General does not include any such, and I ask, what is the harm if you are going to expand the responsibility of the SSA? Then we should ensure that there's balance by providing external independent oversight. And this independent oversight really will serve to secure and to maintain public trust in the institution, in the agency. And it will also be useful in highlighting the shortcomings of any of the internal regulations. And so I think we have to be very clear as to, we must have very clear procedures for the special, anything where it comes to confidentiality and privacy. Madam President, several speakers before me referred to the fundamental human rights of the citizens to privacy. Several speakers mentioned the United Nations Universal Declaration on Human Rights, Article 12. And I ask if we are to surrender any of our rights. In the end, the question is, what rights are we willing to give up in the name of national security? Are we guaranteed to be safer at the end of it? The legitimacy of our Constitution and our very democracy is at stake. We have in history numerous instances of rights being eroded, little by little, until the state wakes up one day and asks themselves, how did this happen? And the fact is that we are all responsible when we agree to give up our rights little by little. And I mentioned before that we are yet to see a plan from this government, and I believe that if the citizens see a clear direction in terms of where the government wants to go in fighting crime, citizens themselves as stakeholders can participate and partner, but you are yet to have a plan being presented by the government. And my fear is that out of desperation, there are citizens who will indicate that they are willing to give up their rights, their fundamental rights that we are afforded in our democracy because of sheer desperation, because of the situation with our crime being out of control. And we in this parliament have a duty to protect our citizens so that we will not get to that place. And that is why the opposition today, Madam President, has put forward several amendments, and it includes oversight mechanisms that should be included in the bill. Madam President, any intelligence services, intelligence services should be overseen by a combination of internal, executive, judicial, and specialized oversight institution, with mandates and powers that are based in law. Previous speakers referred to Joint Select Committee, an independent committee, a body similar to the police complaints authority and so on, with different methods of appointment. An effective system of oversight would include, you can have civilian institutions that is independent of the intelligence agencies as well as the political arm. The combined remit of oversight institutions should cover all aspects of the work of intelligence services, including ensuring that they comply with the law, the effectiveness and efficiency of their activities, their finances, that they are utilizing state resources adequately, and that their administrative practices are in line with best practices. Madam President, I think in this bill we should take the opportunity, the Attorney General should take the opportunity to include that, that manner of oversight. And later on, in terms of the administration and implementation, we should, and I say we as a state, regardless of who is in government, should ensure that these oversight committees are adequately resourced. We should take the opportunity as well, Madam President, to perhaps deliberate on what the expertise of the people we want to be on that oversight committee, the expertise of the people we want to be appointed as director, the other persons, other key positions within the SSA. We must consider and perhaps include the levels of access to information that we want to authorize. And we should ensure that we include measures that would almost guarantee full cooperation from the SSA, whether it is the director or other officers, to the oversight agency. Previous speaker, I believe Senator Ramdeen, mentioned that very recently there was a joint select committee where a state agency, Petrotrin, refused to to bring information, to supply documents, and on the Malcolm Jones matter. And the Parliament really doesn't have any power as such to compel and to ensure that it does happen. I know that the Attorney General's name has been mentioned in issues with regards to that whole Malcolm Jones matter, and I don't know if it is a matter he would want to ponder on when he is giving consideration to these things. Madam President, I also want to make recommendations that when we are dealing with oversight and checks and balances, we must look at the ability of the external body to review the conduct and the decisions of the SSA in this instance, and to give them powers to, for instance, to have investigations, to make inspections or audit. Mention was made of Auditor General. We do know that there is a severe delay, and by the time the report comes, in many cases, very little could be done in terms of action. We have had a number of state agencies who escape where directors take decisions and the report from the Auditor General is not immediately available. And they escape the noose. And there's so much there in the public domain being said about accountability and calling on public officials to be more transparent. But we must ensure that the agencies we empower are given the power to do what they are required to do. We must also make provisions for instance, if an individual feels that his or her rights has been infringed by the SSA in this intelligence agency for whatever reason, that he is able to bring a complaint to the court or to an oversight institution. In other jurisdictions, it could be called an ombudsman, Human Rights Commissioner, there are different names. And these institutions, of course, would be responsible for addressing complaints and claims for effective remedies arising from the activities of the intelligence gathering agency. And they would remain independent, again, of the intelligence services as well as independent of the political arm. The investigation or inquiry by the oversight body could be based on a complaint from a person who feels aggrieved. It could be based on a legal obligation that we could include in the bill if this is being considered, or it could be based on the oversight body's own motion. And I want to mention that there are cases, again, in other jurisdictions where people who feel that they were unfairly targeted had the opportunity to bring up these grievances and have them aired. Madam President, when you seek to give expanded power to an intelligence gathering agency, as the Attorney General is seeking to do with the SSA today, considerations must be given for avenues to treat with grievances. The protection of the citizen of this country should be of paramount importance. The government has a duty to protect the rights of the citizen, and I don't see any measures in this bill to protect the rights of the citizens. Madam President, I want to speak a little bit in terms of the rationale for making this recommendation. Madam President, in order to maintain the integrity of government agencies and public officials, we must hold them accountable for their actions, for their decisions, and any such decisions that they will take while carrying out their duties. And I say public officials, and it applies to politicians, yes, but when it comes to people who will be specially appointed and be given expanded powers, powers especially that could be seen to violate our human rights, we must ensure that as a government and as a parliament, we put measures to protect those rights. Madam President, we are in a society where we pride ourselves in our democracy. And a keystone in representative government is accountability. Accountability enhances public confidence in the agency. And conversely, it would help to ensure that the government and the policy makers, regardless of who is in government, is responsive to the interest of the public and the need of the public. So the situation we have where crime is spiraling out of control and one minister fails and you add 2 more ministers to the ministry and it's still not working and so on, we have to go past that and really look at responding in a tactical, strategic manner. We must look at having quality control mechanisms that would help the agency to demonstrate its integrity. There are agencies in this country now who operate as independent oversight agencies. They are not without their shortfalls. And you have the Auditor General that was mentioned before. You have the Office of the Ombudsman, again, laden with well, shall I say, lessons. There are a number of lessons that we could take from these agencies. And the Police Complaints Authority, again, another agency that has received a lot of public attention. And we could take some lessons from that agency with regards to how persons are appointed, how the powers that are given to them and the checks and balances when it comes to accountability. Madam President, I know that because very often the opposition, the government tends to spend a lot of their time, the members on the other side dedicate a big part of their speaking time to criticizing the partnership when it was in government. Let me tell you that the population is fed up of that. The PNM has been in office. The PNM has been in office long enough to get down to work, and there are many in the population who feel that they are still campaigning and they have not gotten down to work. To the extent where today, and I'm sure that there will be other speakers who may mention what happened in the past. I want to urge every member in this House, those on the government bench as well as on the independent bench, let us use the lessons of the past 21 years of existence of the SSA under the different political administrations and ask ourselves, what were the successes? Was the SSA perfect in carrying out its duties? I am sure that there are areas for improvement. There are recommendations that the Attorney General should have brought today in this bill circulated before the House that he failed to bring. But nonetheless, the procedures of Parliament allow for a select committee or a committee of the entire Senate, but there are provisions for the Senate to make amendments and make recommendations to put these measures in this bill. And I think we are all duty-bound to ensure that that happens before this debate is closed. Madam President, the alternative to that is really for the Attorney General to take this opportunity and completely withdraw what he has brought before the House. And he could completely withdraw it and take the opportunity to do some wholesome development of the amendments if he wants to create a national intelligence gathering agency, because he has failed to do that today, Madam President. I want to give you the assurance, I think you will be better off, the Attorney General will be better off in the eyes of the public and in the terms of how the public would view him, their level of confidence in him. I think the public will have a higher level of confidence in him if he's man enough to say, listen, this was not properly thought out, let me withdraw this, I will come back with meaningful amendments and we can agree on it. I know that he has taken quite a beating in the public domain recently with his pronouncement on decriminalizing marijuana and the Prime Minister's subsequent comment on it. So I hope that in his wrapping up, no pun intended, in his wrapping up, I hope.
Give a peace pipe to smoke.
Clarence, but you're taking advantage of this.
You need to smoke a red beard first.
They come and rescue you.
Smoke a red.
Madam President, I hope that in the wrapping up, the Attorney General
I think the Prime Minister feel again more popular than him.
would be able to speak on behalf of the government, and we will not have a situation as did occur in the public domain. I trust that whatever views he puts forward will be the views of the government, and that we can rely on the views put forward, and that we can go forward with something meaningful to make a dent in crime, make a dent in law enforcement and the intelligence that would support law enforcement. Madam President, some key areas that we should look at based on the past 21 years of experience with the SSA include the manner of appointment. The manner of appointment for the director. there has been much controversy with regards to how a director is appointed. And I say much controversy in that many, including myself, are of the view that a person with the power of the director of the SSA should not be appointed by political appointment. There is need to revise the administrative structure because clearly from the operations and from what we have seen in the media, from the contribution of Senator Mark earlier, the position of deputy director, which does not exist in the law, but which for some there is practical need for, has to be addressed. The provision of senior staff, the qualifications, the manner of appointment for the oversight body. I am of the firm belief, Madam President, that if the SSA is to be given these powers that are proposed in this bill, that there must be an independent oversight body. Madam President, the manner of appointment for this oversight body, as well as for key positions such as the director, should be insulated from political influence. And there are examples of appointment processes that we utilize as well as in other jurisdictions in other nations with similar political and government structures as ours. For instance, where the president could appoint in consultation with the prime minister and the opposition, where the president can appoint based on the guidelines provided, and and we must look at the qualifications and the composition of the oversight committee. So, for example, whether we want to term it a complaints authority, whether it wants to be a parliamentary committee, there are places where there are requirements for members of the oversight committee to be, for instance, retired judges, former military personnel. There must be minimum qualifications. We must give consideration to these things. And the Attorney General has failed in his duty to bring something with these type of recommendations before us.
Senator Ameen, you have 5 more minutes.
Thank you. Madam President, I know the AG had a tough week. He seems to be jittery. Madam President, we can also look at the issue of term limits so that you can break that power hole that interest groups may develop while there. Madam President, in wrapping up, I want to take the opportunity to respond to something that was mentioned earlier by, well, the member is not here. I think it was Topping.
No, he's the chairman of the Coppin.
Right, the Senator Topping, he's not here.
Senator Ameen,
sorry.
yes, the standing orders provide for other members to be referred to by their proper designations.
It's Coppin.
Coppin, it's Coppin, right. So my apologies, Madam President. It wasn't intentional at all. I really can't see his name tag from here. No. My apologies. I don't know the guy. I hold no brief for him, and I have no reason to. So what I just want to mention, Senator Coppin in his contribution earlier mentioned, he's not here, I don't know where he is, but
He went from Ramdeen.
he mentioned that the contribution of the leader of opposition contradicted that of the members in this House. And Madam President, I know that there may not have been provisions to correct it while he was on his feet. And let me indicate to you that the leader of opposition had indicated that while she had no difficulty in principle the provisions of the bill, that that there was need to establish a national intelligence gathering agency. She, in her contribution, the very same contribution that he conveniently extracted from, she spoke about the issue of the definition of serious crime and the idea of saying related to a particular crime and related to really widens that width of people who you can deal with or interfere with. She spoke about the issue of penalty, the offense which carries a penalty of not less than
Senator
5 years.
Ameen, when the reference was made, to the Hansard in the other place of what the leader of the opposition said, it was in respect of one issue. I don't think it is necessary for you to summarize everything that was said by the leader of the opposition in the other place.
Well, Madam President, I thank you. I just felt that the member conveniently took points that could be, misleading. It could be misconstrued as, and that he did not bring the other side of it, and there were several recommendations in the Leader of Opposition's contribution in the lower house with regards to safeguards, with regards to oversight, with regards to the power that would be given to the SSA, with regards to the rationale in the 5-year, the fear of sedition being a part of the list of crimes, and the fact that anything related to the list of crimes that were listed could be considered the need for gathering intelligence. So I pray that the other senators will be balanced and fair in their contribution as they make their contribution to this serious bill. Madam President, in closing, I thank you for the opportunity, and I want to ask every member of this House that we take into consideration the seriousness of the matter before us. I think it was more serious than the Attorney General may have anticipated when he brought this matter to the House, and that you will have the full cooperation of the opposition in bringing meaningful, balanced legislation that would protect the rights of the citizens of this country and ensure that the protective services have the necessary information, but not sacrificing the rights, the fundamental human rights of the citizens of this country. I thank you.
Senator Junkere.
Good evening, Madam President. Good evening to fellow senators of this honorable House. I'm very grateful for the opportunity to address this august chamber on the Strategic Services Agency bill. Through you, Madam President, and I'm sorry that he's leaving, but I wish to commend Senator Mark on his ambition to study law. I don't envy him his task. I know that he's eloquent enough. He has the passion.
Exam by yourself.
Well, anyone who wishes to go down that road, I admire you. I won't descend to actually try to assist. I've stopped teaching law. And there are no fewer than half a dozen other very qualified, competent, capable attorneys in this august chamber who can do a much better task than I can. I say that because lawyers tend to speak in a particular way. But we need not speak the language of lawyers when addressing the law. Sometimes we ought to speak the language of the citizens on whose behalf we advocate, because it is their interests that we serve. So I speak this evening not as an attorney at law, but as a citizen. I don't need to be a drug lord or a gang member or a terrorist or a money launderer to seek the interests in the amendments to this bill. I can speak as a citizen who uses a phone, a citizen who uses a computer, a citizen who has an opinion, who has friends, who shares these opinions with friends on the phone and on the computer. I speak also as a country boy come to town who uses GPS mobile applications so I don't get lost in the big city lights. And as a citizen, as someone speaking hopefully on behalf of others who have similar concerns, many of the arguments that have been proffered here by both sides and even in the independent bench, with the greatest respect to the persons before me, a lot of the arguments, if I am an average person, it flies over my head, which given my stature is not a difficult task. But concepts such as constitutionality and proportionality.
Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until 9 p.m.
Honorable Senators, the question is that the Senate continue to sit until 9 p.m. Those in favor say aye. Aye. Those against say no. The ayes, I think the ayes have it. This Senate will continue to sit until 9 p.m. Continue, Senator Junkere.
Grateful, Madam President. Now, instead of proportionality and constitutionality, I think the average man on the street simply wants to know three basic things, Who is going to be monitoring me? Why will they be monitoring me? What will they do with this information? That's it. Now, if we dovetail out of those three simple points, the concerns can zero in on these people who are going to be monitoring me. Who are they? This person under whom they act, the director. Who appoints him or her? Do those persons have persons to whom they report? Who appoints them? From whom do they receive instruction? Why will they be monitoring me? What activates surveillance on poor me? What will they do with this information? I have heard, Madam President, young ladies complaining about officers knowing where they are and what they've said on phones. How do they know this? I don't wish to impute improper motives on anyone in or out of this house in terms of the manner in which information that is currently being elicited is being used. But these are legitimate concerns, and if it's on the streets, if it's in the minds of the citizens, it ought to be in our minds. Because the laws that are created here affect the persons that are bound by them out there. So we need to pay attention here. But we have to think about what they think about, because that's what they put you here to do. Now, as an average man, almost everyone has a phone, yes? Some have two. How many people still use a Me Too, though? How many? Not very many. Madam President, just the term Me Too brings a look of scorn to most people's faces. You know why? Because even my 6-year-old daughter is begging for a smartphone because she knows that phones no longer just make phone calls. A phone can be used as a calculator. It can be used, as she's recently found out, as a mirror, as a camera, a flashlight, and quite possibly a tracking device. Now, phones aren't just phones anymore. Look at the size of this. This is my phone. It almost looks like a tablet, probably because I'm holding it. You can say it's a phablet. I tell people it's not a phone, it's a multimedia communications device. And it wasn't cheap. But the number and the multiplicity of uses of this device is what justifies the expense. Now, I'm not here to market for Samsung, although B-Mobile is my preferred network. But I make this analogy to draw reference to the phone as a tool and ask that this Honorable House looks at the SSA as a tool. Why have a tool that has just one use? How I've seen this amendment is that you are trying to make multiple use out of one tool. I hope I have not oversimplified what the Attorney General has been trying to do, but in order for me to understand in the mind of the man on the street how I see it, you have a bill that empowers, an act that empowers the SSA to do one thing. And given that you've spent all those resources, all that time, all that money to do just one thing, and you have the ability to do other things, why not use it to do those other things? So in principle, I too have no difficulty with expanding the powers of the SSA. Now, in that way, the monies that have been expended all these years and that will be expended in the future, it can somehow be justified. Because rather than having the police, the customs officials, the FIU scrambling for information, we now have one reservoir, one source of information, one source of intelligence. Now, quite like summer school on political integrity, police intelligence appears to be a contradiction in terms most times. But now, with the expansion of the SSA's powers, we have the ability to arm and equip these ancillary bodies with the intelligence, with the knowledge, with the information they need. Now, of course, there's the antithesis to that. What about our civil liberties? What about our privacy, our right to privacy? Mr. President, Vice President, my sincere apologies. We speak about our rights to privacy, but I bet you, if anybody lost their phone in this august chamber, it would not be unreasonable to expect that they would want everybody here to be searched before they left. Take that to its logical conclusion. How many people care about the privacy of others if their child is kidnapped? I would personally want to listen to every single phone call on every single frequency to ensure that whomever is responsible for the offense can be brought to justice. And privacy is an illusion, because sometimes we think that what we say is amongst ourselves, but we unwittingly share our own information when we are careless with it. But if we entrust our privacy to persons who use it for the protection and the security of our nation, it's a small price to pay. I say that because I have nothing to hide. I trust that this august chamber, in their conversations, professional or private, also will have nothing to hide from the SSA. So respectfully, I support the expansion because I think that the utility of the expansion justifies the means. However, the ordinary man will still insist, even more so, that if you are expanding the powers of this tool, you must also control the responsibility with which it is being used. And it is a legitimate concern. And I too have some legitimate concerns that I hope the Attorney General will take with the good intentions that these recommendations are being made. Now, firstly, I look at the list of crimes that are now being defined as serious crime. And it occurs to me that crime doesn't occur in puddles and ponds. You don't have drugs here, homicide here, kidnapping here. Crime and criminal activity, bad acts, are like streams that flow into rivers, that flow into the sea. And if we do not stem the flow, we could end up with a tidal wave of criminality, the likes of which we have never known. So if we have an opportunity now to look at these streams, we will see that many of the homicides that are reported, I don't know what the statistics actually are, but the perception is where they get shot, northeastern, that is drug related. So if we have a tool used to monitor drug related activities, why not use that tool in surveillance of persons committing homicide? I see there seems to be a paranoia regarding terrorist acts and terrorist financing. Okay, so that amendment would be made. Hijacking, kidnapping. It's not a stretch of the imagination that persons involved in illicit drug trade may also be involved in kidnapping. Obviously, money laundering is a byproduct of the drug trade, as too is smuggling. When we talk about, they have it here, human trafficking, trafficking in children, the porosity of our borders that will allow for the movement of humans can also allow for the movement of drugs. And the information culled from strategic surveillance of these routes can ably assist us. I must confess, when I see computer misuse as a serious crime, without making any admissions, the types of things persons do on their computers may leave much to the imagination when it comes to the definition of computer misuse. Cybercrime, the definition of cybercrime by extension, I'm not sure to what extent one can say cybercrime is serious crime, but I accept the Attorney General's position that it's covered under the Act. I just find that treason, as serious a crime as it is, the definition of treason and what activates and what triggers the need for surveilling someone who they may be suspected of treason is very slender. If someone has an anti-government sentiment and expresses it in a forum which is open to monitoring and surveillance, what becomes of them? It is for these reasons I respectfully suggest that no matter how small the minutiae of these items listed under serious offenses requires a collaborative effort across the political divide. It may not require much amendment. I had an opportunity to look at the proposal for amendments proposed by the opposition, and I don't see much difference in the list of serious crimes, and I think there could be consensus there. I respectfully suggest a hard look at the appointment of the director of the SSA. It appears to me, objectively speaking, that it's untenable that someone with so much power, with so much responsibility, is beholden to a minister, cabinet minister. I think just so that the appearance of impartiality is maintained for the benefit of the persons we surveil, the persons we serve, that the person who is appointed director ought to be seen as someone that can be trusted by everyone and appointed by no one in particular. The average man on the street will be concerned about the protocols that will effect surveillance activity. They will be interested in hearing about the strengthening of any sanctions to be imposed on any officer who will misuse or mistreat information that comes to their hand under the powers granted by the SSA. It will be useful to set controls in terms of the time this information is held, the purpose and the use for which is employed, and possibly even the imposition of a very transparent and public grievance procedure, so that if any citizen feels that the information has been misused or improperly obtained for no good reason, they may have recourse. Because when we are doing these things and we are asking persons to submit to these inconveniences, the benefits that arise or accrue from it must not just simply be the actual security of the nation. It must also be the feeling that the relationship between the state and its citizens, it's one based on trust. Once you engender trust in the people you govern, and you make it out that these are people you serve, they will be happily governed and they will be happily served. If this act, this bill in its present form moves forward, it should receive support. But if it is tweaked to include the relevant amendments that will ensure that our citizenry feel comfortable to surrender what they perceive as their right to privacy in favor of a more secure nation, then it ought not to be objectionable to anyone, no matter what color t-shirt you wear before election. I see Senator Mark is with us again. And I know that his passion for law will continue to grow, will continue to increase, and ably assisted by persons on both sides of the divide, he will make it where he ought to be. For my part, I no longer teach the law, but I can share the little I have left with you. You will realize that in law, there are a lot of Latin phrases. Through you, Mr. Vice President. There's one particular phrase by Marcus Cicero, not his godfather, cannot remember his middle name. Legum servisumus ut liberi esse possimus, which loosely translated means we are slaves to the law so that we may be free. What the government seeks to impose is a measure that could appear to enslave us by us giving up what we perceive to be our privacy. But it is done with the intention that we shall be free of the scourge of criminality, which, if left unchecked, will swallow us whole. So I respectfully ask members of both benches of this august chamber to think of the man in the street who, for no good reason, thinks that you're coming to listen to him on his phone. Before you impose measures in how you do that, listen to what he has to say and make the appropriate amendments that makes him comfortable to submit to this new regime. Madam President, welcome back, and I thank you.
Senator Ramkissoon.
Thank you, Madam President, for the opportunity to join in this debate at this hour, almost 8 p.m. Before I start, I must congratulate the temporary senator on our bench for doing quiet justice with short notice, excellent, eloquent delivery, and valid contribution to this debate. I must commend him. And, Madam President, we do acknowledge and admire the passion of the Honorable Attorney General in relation to operationalizing the laws of Trinidad and Tobago. It could be quite frustrating for one to try to have written law in the system and only serve as dead paperweight. So I do understand it can be frustrating for the Honorable Attorney General. And at the last sitting in this very Senate, he gave a snippet or a prelude to the Strategic Services Agency Act with hopes of its achievements. And upon reflecting on the last sitting, Madam President, I must take just a moment to sincerely thank the coordinator of the independent bench for acknowledging and correcting one of my grave mistakes due to oversight on my behalf. At the last time I was sitting, Madam President, I rose to speak on a private motion which I brought to this House. Due to oversight, I made a grave error in which it was corrected at last sitting, and I must say I do commend Senator Wade Mark for giving way to bring forward my motion, as well as Senator Khan for acknowledging and also agreeing to this arrangement between the benches, and for all senators for supporting the motion. I do thank them all. Madam President, we are here to speak about the Strategic Services Agency Act, the amended version. The last time it was amended was 1997. And Madam President, I do commend the Attorney General and his team for their continuous efforts to reduce the negligence, as he had explained in his opening remarks about the prison system and how he was able to make an impact, a positive impact, by confiscating contrabands, also intercepting phone calls, and different sorts of avenues he was able to enforce through the authorities. Now, I must give him a little advice. At my last contribution, or one of my past contributions, I spoke about the Netherlands prison system. And the prison system in Netherlands is actually making money where they do not have prisoners to house. So they had 19 prisons actually closed down. So maybe we could learn something from that system, and maybe we can make some money in our prison system. But that was just a side note. So, Madam President, after reading this bill, or this act, I must say it is very important to hold our institutions accountable for what is written. We have very good drafters, they have written, we have regulations, now we need to hold them responsible for what they are committing themselves to do. So I read this piece of act and I said, okay, my initial thoughts, as a citizen of Trinidad and Tobago, I would have zero tolerance for any sort of crime after this. I do not expect to ever get robbed. I don't expect anybody to do me anything, because you know all the criminals. You have their phone calls, you have their names, you have database with all information. I should be free to walk as I please. I should be able to go to the car park and not have a security escort me there, because I know I'm safe to do that, Madam President. So I thought, okay, this is great. But then I remembered we are not in an ideal world. We are Trinidad and Tobago, and we are unfortunately the 85th in the most corrupted countries in the world. So then I thought, okay, well, maybe this may not go as best as I thought. So we have many different agencies. And when I really thought and listened to the Honorable AG in his opening remarks, and also did my own research into this piece of legislation, we're looking specifically at the Strategic Services Agency Act. And unfortunately, I had to come across this very bold statement, which I have to make, is which I do not support this amendment. And I will give you reasons. It is not the reason you thought initially by hinting it's the reason why we may not support. I'm going to list at least 5, permit me, hopefully my time will allow me to give you 5 reasons as to why I do not support this piece of legislation at this time. So my first point, we have not operationalized our existing laws, and you have listed many pieces of legislation. You have listed the Constitution of Trinidad and Tobago, the Financial Intelligence Unit of Trinidad and Tobago Act, the Justice Protection Act, the Anti-Terrorism Act, Proceeds of Crime, Strategic Services Act, the Strategic Intelligence Agency, which was just a cabinet note in 1994. So we have a lot of legislation, I mean good legislation, written, well written. Why is it the first step, instead of trying to operationalize or trying to amend the existing systems or hold persons accountable, why is the first step that we're trying to add more responsibilities into this present agency? And I couldn't really see that connect, Madam President. I couldn't understand. We have an agency here, 21 years old, and we have not, well, I mean we the public. You may have statistics, but we don't have statistical data to show this is working for us. This is serving us. Madam President, it was only when I had this came up into the Parliament and I had to sit down and read, I said, oh my goodness, we have an agency dealing with drug trafficking. Oh my goodness, why do we have drugs in the streets? I could not believe that. And I mean, it was such a great agency talking about centralizing unit, a database. They even spoke about trending data too, you know, that is an existing past law. It's not something that we're trying to amend, that is there written. So I really could not see the connection, and that is why one of the reasons I could not say yes to this amendment. Now, I always like to share data and findings with the Senate as well as the listening audience to know where I got my information and for them to base their own opinions. So I looked at a review of the national security sector. It was dated April 2009, and it was conducted by a review team led by a Canadian Major General, Cameron Ross. And I quote, Madam President, "There is a considerable overlap in the collection, analysis, and distribution of intelligence among the security agencies. Having Special Anti-Crime Unit of Trinidad and Tobago, Defense Force Intelligence, Security Intelligence Agency, Special Branch, the SSA Unit, and NSCS, all involved in difficult to justify in a country as small as Trinidad and Tobago." And this was a quotation from a review saying that there's so many agencies involved, there's so many overlap. I believe we heard that already in the Senate. Why is it that now? And this is surprising enough, this review didn't even take all the agencies into account. I mean, I must say I was very educated by the number agency because I learned of the customs and customs and excise enforcement and operation units. I think they should probably exercise. That's probably why I said that. Sorry. I do apologize. They spoke about the Integrated Threat Assessment Center, a National Coastal Radar Surveillance Center, an anti-kidnapping unit. So all of these, again, is agencies that exist in Trinidad and Tobago. They are not new. They are existing for some time now. So I felt, okay, is it that we have more agencies than solve crime? So I felt that we needed to get some statistical data. So I requested for the assistance of the parliamentary librarian to request data from the judiciary to share how these intelligent agencies have impacted on the criminalizing of cases. And unfortunately, the response was they do not have that information. They do not have statistical data to show where these intelligent agencies have solved cases, have helped us to know if you're guilty, innocent, have showed data recorded or collected, however they are doing it, because I know there's a lot of software available that can record all your emails just from a click of a button. They can pull up what dates and they can zoom into who you are and stuff like that. So there's no record showing that this is of help to our very backlogged judicial system. And it was very scary to know that. And one of the 1995 SSA mandates, Madam President, was to trend, analyze, and interpret patterns of criminal activity that relates, but not limited to, dangerous drugs. So, Madam President, it was good to see, I did find one piece of evidence where the SSA was involved. And if one wants to find it, they can go back to a Guardian published article, June 9, 2015, where it says, the SSA provided much needed intelligence to support ongoing criminal investigations. Full stop. It did not elaborate. So we hear of it. I only knew about it when I had to do research for this debate, 21 years in the making, and I still don't know what it has done for my country for this 21 years. My second point into why I am against this piece of legislation is that we are attempting to set up legislation to build infrastructure to fight against serious crimes. And the serious crimes is defined in the amended version. And when I read the 1995 version and the inability to operationalize the existing law, I was quite alarmed that if such legislation existed for 21 years, and we still have rampant traffickers, drug traffickers, and other criminal activities going on, what next? So a little history. I didn't really hear any of the members really deal on it, but this was something that happened in 1995 that was enacted by the PNM administration on October 4th, 1995. And according to the Act then, the agency was set up to act as an office for centralizing information that could facilitate the detection and prevention of illicit traffic in narcotic drugs, psychotropic substances, and precursor chemicals, for coordinating operations for the suppression of illicit drug trafficking and drug-related matters, for cooperating with the services and corresponding services for other countries. And that is the existing law as it says. So the existing law. But Madam President, let's check reality. So since I couldn't get any statistical data from the institutions, I needed to go to the public domain. So what's available publicly? And what is it available? If you look at the, which one is this? Guardian, the 21st of January 2016, 2 illegal guns, 6 million in drugs seized in raid. And the article goes on to say, police said acting on a tip from a concerned citizen, they were able to recover the illegal drugs and guns. Okay, no agency. Another article published July 3rd, 2015 from The Guardian, again. Guns, drugs found in police raid. And it went on to say how many laptops, computers, DVDs, and cell phones that was guarded. Again, a raid. Police activity, normal, run-of-the-mill. Another one, drug trade fueling crime, Madam President. The Guardian published this on the 13th of January 2015. And it had a nice piece of statistics linked to violence. According to the gun policy country profile of Trinidad and Tobago, in 1995, 44% of the 135 murders were committed with guns. And in 2009, 72% of the murders, of 506 murders, were because of fatal shootings. So they're relating the gun trade and the drug trade industry. I didn't realize that illegal weapons and drugs were directly related in that sense. And The most interesting article I came across was the 24th of September 2010. And Madam President, please permit me to share some of the information in this article, and because it was quite applicable to this SSA agency. And the first line is, British and Spanish police are investigated why 1.5 tons of cocaine worth close to 1 billion left Chagaramas earlier this month aboard a yacht headed for Spain. Now, Senator Mahabir alluded to this earlier, where how much crimes pass our shores and we are not aware of it. But it was quite interesting. The article went on to say, in 2002, a British court was told several politicians from Trinidad were said to have a close alliance with the British millionaire drug pusher who was at the time in hiding from the British authorities. And the article went on to say they were involved with this shipment of drug trafficking. The court also heard that in conjunction with the Sea Mist, which was the yacht that they was in question, a series of yachts left their Chagaramas laden with cocaine and into the ports of England and Europe. Local intelligence agencies are said to be closely working with their international counterparts on Monday's bus. That is from this article. It is quite interesting, Madam President, to hear the reasoning behind this drug trade. So that is what we find in the public domain in relation to intelligence, in relation to safety of our shores, in relation to operationalizing the laws of Trinidad and Tobago. More data, Madam President, was found in the osac.gov website, and it had a nice quote from the then acting police commissioner, Mr. Williams, and in August 2014, he noted despite the seizure of 380 firearms, the highest number of firearms taken off the street for that period, he said 75% of the murders was due to firearm or due to guns. And again, the increase in that highlights the growing problem of imported and often illegal weapons and firearms smuggling. And they related again in this article that drug trafficking and gang-related activities continue to fuel the demand for illegal weapons. So quite a learning. Madam President, Trinidad and Tobago is our country. And when we hear statistics that say the detection rate for murder was 6.1% for 2014, with existing intelligence agencies, I am surprised. Not knowing about intelligence agency, I will not be surprised. But knowing about these things and having such a low detection rate is a bit confusing. And even the murder rates for Trinidad and Tobago was approximately 35.3 per 100,000 inhabitants, oh gosh, according to the 2014 United Nations and the World Health Organization global reports. And that report, Madam President, went on to say that murder rate continues to be driven by primarily gang and drug-related activities. So we know the root cause, according to these reports and the statistical data, is due to drugs, and now drugs is also influenced by the illegal weapons that come into the country. And we have an agency set up with that sole responsibility to monitor, to trend, to centralize data in relation to our drug trafficking in our country. And yet, 21 years later, it feels like we have lost control of it. Again, it is very difficult to understand how we are trying to give more responsibilities, because that's what I interpreted it to be, to an agency that is not performing. We're giving them just drugs, the honorable, just drugs you have them to look at, just drugs you centralize, just drugs you're trending. And they can't give you data for that. And the thing is, we have other institutes, like your financial institute, your anti-kidnapping unit. All these people are gathering the information about our citizens, and I hope the criminals, I really hope for my sake and your sake and everyone's sake that, Madam President, they are gathering information that could help save our crime situation, because that's what we want. We want less crime in Trinidad and Tobago. Throughout the world, we have people sending out bulletins, do not visit Trinidad and Tobago. That is disheartening. Nobody wants that. But we want to ensure that when we write laws, I mean, a lot of thought and time goes into it. It's not something that we snap and happen. When we have a law, we expect it to be enforced. If it's not enforcing, we need to fix that problem before we bring more pieces of legislation to confuse more people. Because if we have, if I'm telling you now, this agency is supposed to do all these serious crimes, and they can't even get one of the serious crimes right, how am I expecting you to give me information for the rest? And that's my point, Attorney General. So let me see if I can make another point. I don't know how much more time I have. Okay. I think Senator Coppin spoke about the amount of money for the SSA. And the Guardian, June 9, 2015, published the recommendation coming out from the SSA that says they need to buy new equipment in 2014 to improve the confidentiality of information developed, gathered, and analyzed by this intelligence unit. So we still have now a new area now. We may have a breach because we don't have proper equipment now to ensure that our intelligence is safe, Madam President. So the cost of this project was about $500,000 just to operationalize that part of it. I am yet to fair how much to ask what's going to be the cost of all of these additional responsibilities. I hope for our country's sake it is zero, because we are looking at value for money, accountability. And if we can't get the value there, there's little that the citizens can have faith in this. And a very young, wise man told me that you cannot expect blood from a stone. So I don't know what we expect from this agency, since it's just like a stone right now. So we expect value for money. And I think in 2013, the allocated budget was about $107.6 million, just to give you an idea of how much money we feed into these agencies. My third point is the fear of this information ending up in the wrong hands. And for the listening public, Madam President, I thought of this very simple analogy that people could connect with, because we say SSA, we say SIA, we say all different terms that sounds very fancy. And I thought there was a simple thing that local persons can connect to. And there's this new series, this fictional series running on local television. I don't know how many persons look at it because we don't have the luxury of TV time. But for the listening audience, there's this excellent television show called Person of Interest. Do you all know about it? Okay. Person of Interest is about these two guys who have developed a software or technology to monitor persons and ensure that they could zoom into crime and prevent it from happening. And I felt that this was something that we're trying to do with the SSA, or with operationalizing our laws, by really having this technology or digital technology to ensure that we can zoom into our crime situation and eliminate it. One of the biggest fears of that television show, and what they try to always cry out, is if the guys who are using the software was ever kidnapped and this information ended up in foreign technology or foreign hands, So then we have the anti-terrorism activity happening, where another country now has access to all your information. And that was the biggest scare. Now you have your government officials' data, you have your bank's accounts, you have all this information in one hub. And now any country can come now and access that information. I found that to be quite scary, and I felt that show really promoted it. So I felt that is something that persons can connect with what is the SSA, what we're trying to do, and it really can show that piece of how digital technology that can be used to save a life, but also can destroy so many others. I want to just touch on trust, because we have intelligence agencies throughout Trinidad and Tobago. But trust, Madam President, is very, very important, because you can't have buy-in if you don't trust the system. And if you all look into the Police Complaints Authority, the allegations against police officers, between the period of December 29, 2010 to 2011, there was 255 complaints. For the period of 2011 to 2012, 340 complaints. 2012 to 2013, 470 complaints. 2013 to 2014, 491 complaints. They're not reducing, they're going up. And this is the fact also that citizens are afraid to go to the police station to report the police officers or any wrongdoing because of fear of victimization or fear that they would be hurt or discriminated against. So we have complaints lodged by some brave souls, and I'm not sure what is happening to reduce those numbers instead of increasing after year by why they're not decreasing. So public perception is very, very important. And that will lead me into my fourth point, which is the misuse of intelligence agencies. And unfortunately, this has happened in our sweet country, Trinidad and Tobago, where there was an article published in the Trinidad Express, November 13, 2010, Spouses as Spies. And it had SIA hired friends and relatives to be informants at $20,000 a month. I don't know if this is true, but it was published in the newspaper for public purview. And it also went on to where the unit, which was not known to citizens or even the police officers, and it consisted of 200 civilians. So again, we need to be mindful, because unfortunately, Madam President, we are mortals and we don't live forever. And what we're putting up for now, it needs to be able to exist throughout time. So if the persons on the other side and this side are not here, whoever comes forward and is here to enforce the law is enforcing something that is not illegal or can be used for illegal activities. So to have civilians and not involving your police officers or your citizens to know about this type of technology is a bit alarming. Okay, I didn't want to go through read the whole article, but if you want, I can quote. Sorry, no, not a problem. Okay, what the gist of it was that the SIA was financed by the Ministry of National Security with no level of accountability, right? It was paid as much as $20,000 a month to informants, inverted commas, who supplied no credibility of information in the fight against crime. The unit, which was not known to citizens or even police officers, consisted close to 200 civilians and personnel from the Army and the Coast Guard. According to a reliable source, the article published stated that close to the Canadian team hired by the police service to conduct a forensic audit on the SIA, allegations of heavy corruption within the unit was said to happen. And speaking with the Sunday Express in that time, on the condition of strict... Y'all know the article? right, the strict anonymity, the source said many of the agency's informants were friends, relatives, and spouses of the SIA personnel. These informants were paid in cash so that their identities would not be compromised by the tracking of bank records. The SIA, this was published in the November 13, 2010. And it even said that the SIA had several bank accounts which were concealed as company accounts to avoid the exposure of secret agency. So this is something that happened in Trinidad and Tobago, and this is a case. Now, something that you were actually listed in, I saw in the November 13, 2010 Newsday, clear and present danger, where there was the talk of the illegal wiretapping in our country. And you were actually listed as one of the names that was tapped. I don't know how you felt, if you would like to share with us. Oh, sorry.
Please.
I do apologize.
Yes, when you're addressing the Attorney General through the chair. Thank you.
Definitely through you, Madam President. I would like to know how the Honorable Attorney General felt when he learned of this invasion of his privacy. Did he feel a breach of confidentiality when he was listed as this name? Because I believe he was serving in the Senate at that time, Madam President, and he was just a government senator, opposition senator. So how would he feel, how he felt, or how any of those persons listed felt? Because I guess this is against their will, against their knowledge. I don't know if, well, the Honorable Attorney General, Madam President, through you, is saying that it wasn't true, and I hope that it wasn't true, and I hope that we can retract articles like this in the newspaper. But anyways, it is also noted that media, journalists, and information was collected on them. I don't know what the information did, but it is very much alarming to know that your name is appearing on a list to be monitored, and you don't know why. And I don't know if my name will appear on a list, and I don't know why. So, no, I do not say that, okay, this is not already happening to me, because my phone is drop my calls when they hear Chinese speaking sometimes, Madam President. It's so scary. But nevertheless, I have nothing to hide. But it is not the point of hiding something. The point is your rights as a citizen. Okay? Are you going to have a breach of confidentiality because someone feels that you should make the list? So it's a little bit concerning. Okay? My last point is wastage, Madam President. And oh gosh, I don't know how much numbers I have.
It wasn't following. She made four.
Honorable Madam President, wastage. The Honorable Attorney General mentioned this in his introduction on the SSA Annual Report 2013, which was laid before Parliament, and it highlighted some interesting ones. Unfortunately, I did not see the 2014 one on the website. They only had the 2013 as the last updated report. And it was quite interesting, though, because they had work completed and they had assessment of regional security threats as one of their completed jobs, as we would say, from the SSA agency. This is great. So what is happening with these threats? Where are the assessments? Are we using them to solve crime? Is the National Minister of Security aware of these assessments, and are they being used to fight crime in our country? Another one, they went on to say that they had a final edit of the National Drug Policy and Operational Plan 2014-2018. I would wonder if this plan was rolled out and what happened with this information. This is good work. I'm sure it took a lot of time to prepare and do. If the SSA is a functioning unit, I would believe it is, because we are putting money and we have budget allocation to it. So what is happening? Where is the disconnect? If there is a disconnect, or if we need to fill the gaps.
Senator Ramkissoon, you have 5 minutes.
Okay. Thank you, Madam President. Madam President, there is a lot of statistical data out there that shows that Trinidad and Tobago is affected by cases of corruption and inefficiency. Even the 2012 United Nations Development Program Caribbean Human Development Report had a piece of the report titled Gangs and the New Law in the Urban Trinidad and Tobago, with approximately 100 criminal gangs identified in Trinidad and Tobago. We have so many different reports identifying things that I believe the agency should be identifying and should be putting out there for the public to know. This is how we can trust an agency and understand the functioning of it. And then we can say, okay, yes, we are seeing value for money. Let's add on these extra serious crimes to them. No problem, we can have them go for kidnapping because they're performing. They're performing, they're accountable, and we are proud to say they're agency of Trinidad and Tobago. Now we have instead a lot of agencies, a lot of overlapping. We're not sure who's doing what. And maybe they're stepping on each other's toes by having overlapping and not sure who's responsible for this area and who's responsible for that. I don't know because we don't have that information available to us. But we must know what is our capabilities, what our performance, and what is the success of the SSA, the last amended 1997 version. So I do understand the government faces numerous challenges. We have an overburdened legal system, no doubt. We have influence of gangs, drugs, but we also have lots of intelligent agencies. So we don't give up. We don't attack. We say, well, let's cut out the fat, as the local term is. Remove agencies that are not functioning their duties. And if you want to have an overarching system and have one agency, then say that. Say that we don't want to have the anti-kidnapping unit anymore and we just want to have a serious crime unit. I can understand the link, but why are we having all these different agencies? I can't really understand that because we're not holding them accountable. So I found this really nice quote from Julian Assange, an Australian computer programmer. He's a publisher and a journalist. Intelligent agencies keep things secret because they often violate the rule of law or of good behavior. I hope that is not our case. We are not violating our laws and good behavior, Madam President. And I do look forward to having this piece of legislation withdrawn from the Parliament. And I have laid my case, Madam President, for consideration. I do thank you.
Leader of Government Business.
Madam President, I beg to move that this Senate do now adjourn to Tuesday, the 10th of May at 1:30 p.m.
Honourable Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Solomon, you have 10 minutes.
I'm grateful, Madam President, and I see the Honourable Minister of National Security is here. I'm sorry that it was so late in the day, Minister. But my motion is the failure of the government to properly address the safety and security of the lives of state witnesses. Madam President, this is of paramount importance to the proper functioning of our society. The police rely on the information from the public. Witnesses for the state must be made to feel safe, secure, comfortable in the giving of their evidence. If the public feel as though the witnesses are not being made to feel safe and secure, then what would happen is the public would be reluctant to ever come forward to give evidence in serious criminal matters. Not only for the safety of the state witness, but for the proper functioning of the entire judicial system. Without the public and without state witnesses, there will be no detection, there will be no conviction, and the entire criminal system would fall apart and crime would be rampant. So, Madam President, there are a number of state witnesses and executions of state witnesses that have been happening lately in the media. A number of state witnesses who have come forward and said about their treatment under the State Witness Protection Program. In particular, there was a young man by the name of Daniel Ned, and I refer to a article March 21st, 2016, where 14-year-old Darian Ned finally met his death yesterday. He was a witness in a contraband deal. 2 men chopped off his limbs with a cutlass and then set fire to his home, leaving him to die. Madam President, the details of this horrendous murder are gruesome, and I don't want to go into it just for the alarmist side of it, but it is imperative that the ripples effect that this sort of horrendous crime has, it creates fear. It makes the public feel as though once you step forward and you take the chance to give evidence, you will be executed. Your family can be executed, you can be intimidated, and it's just not worth it. It's better to say nothing, do nothing, and stay out of the reach of the criminal world. Madam President, this is why it's imperative that I ask the Minister of National Security to please put effort into keeping state witnesses safe, keep state witnesses secure, because everything relies on the fact that these state witnesses come forward and give evidence. Another alarming case came to light recently, a case involving a police officer witness. She's a state witness called Nicole Clement. She actually was the main witness in a case involving 6 of our own police officers who are alleged to have murdered 3 civilian citizens of Trinidad and Tobago. The evidence that Clement gave in the magistrate's court actually pointed towards these officers having received instructions from senior officers. And although we do respect the hard work of the officers, we also have to understand that this state witness has risked her life by coming forward as a police officer. And to this day, she has not, 3 years on, actually been offered police protection. 3 years and 9 months later, she's still not yet in the Justice Protection Program. Madam President, that is unacceptable. She's guarded by fellow police officers who know her movements because those are the same colleagues of the officers to whom she's given evidence against. She's gotten threats to her life. She's been moved to 4 different safe houses. She has a 4-year-old child who's had to leave school. She was promised that she would be taken out of the country and kept safe. And her family are still exposed as she is. Madam President, this is crucial that the Minister of National Security make a concerted effort to keep not only the state witnesses safe and secure, but also their families safe and secure, and that they must be made to feel comfortable, Madam President. There's another state witness who recently came into the public media's attention. She's a young Muslim woman who is giving evidence against the murder of Amos Dick, who was murdered on 17th of October 2015. She says that she was kept in a safe house, Alicia's guest house. On 2 occasions, she bumped into people that she knew. She says that she wasn't given halal food. She's pregnant. She was moved around from safe house to safe house. And on 1 occasion, information came to light where she was moved from the safe house and taken to a police open dormitory where she spent the night. Madam President, she gave evidence about a possible terrorist attack against this country. She gave information about terrorist training and planning an attack on this country. We haven't heard anything more of that, but it is crucial that such witnesses are kept safe and secure. And through you, Madam President, I beg the Minister of National Security, if you can please make an effort, because the entire nation is depending on the system to work and the witnesses to be made safe. Thank you, Madam President.
Honorable Minister of National Security.
Thank you very much, Madam President. Madam President, I heard Senator Solomon a while ago, and he started off his presentation with respect to the failure of the government to properly address the safety and security of state witnesses. And I really much asked the question as to, in terms of his own thesis, the failure of the government, where did he get this empirical evidence? Where is his measurement in terms of assessing the failure of the government to protect the state witnesses? Madam President, from the outset, let me say that in dealing with issues pertaining to the state witnesses, it's a very sensitive area, one in which security classification in dealing with any witness program in any country normally deals with two classifications, secret and top secret, because of the very nature of the program, Madam President, so that my information here will be very much guarded and be very responsible, Madam President. Madam President, the Trinidad and Tobago Justice Protection Program, which is commonly referred to as the Witness Protection Program, is in conformity with the Justice Protection Act of 2000, which was in fact became operationalized in 2003. Madam President, the program provides for the security and support of witnesses and their dependents once they are willing to procure, to provide a certain kind of evidence that is necessary in dealing with crime and criminality in Trinidad and Tobago. Madam President, the programs support providing payments for participants to meet his or her needs, and also living expenses for his or her dependents. The provision of psychological assessments, diagnosis and therapeutic interventions where necessary, and other support as required to ensure that the witness is able and capable to give the necessary evidence, Madam Speaker. Madam Speaker, the offenses... Madam President, sorry. I know you want to come and join us here, you know. I will not be deterred, Madam President. Madam President, the offenses that give rise to these protections are listed in the first schedule, and I will not go through the entire list, but just to show some example. Situations such as murder, manslaughter, treason, sedition, piracy or hijacking, possession or use of firearms and ammunition. The list goes on, Madam President. Madam President. But more importantly, Madam President, the Witness Protection Program is a voluntary program. It is one in which you cannot entice, you cannot induce, you cannot coerce a witness to join the program, Madam President, because that has implications for the legal aspects. And so, Madam President, the Witness Protection Program entails a rigorous assessment. It entails a psychological evaluation. And there's certainly input from law enforcement and the Director of Public Prosecution, Madam President. But more importantly, Madam President, in order to get into the program, the witness must sign a memorandum of understanding. And that memorandum of understanding must be not only signed by the witness, but it must be signed by an officer so authorized by the Minister of National Security, who is in fact the director of the program, Madam President. Unless the witness signs that memorandum of understanding, because in joining that program, Madam President, of course there's certain kind of inconvenience, because it's for your sake, the security and safety of the participant and their dependents. And unless you sign that memorandum of understanding, then, Madam President, it is difficult to enter in the program. And so I really want to understand whether in Senator Solomon's investigation, did he understand that some of the people mentioned were not in the Witness Protection Program, because some of them did not, in fact, were willing to sacrifice their time, did not sacrifice, was not willing to sign the memorandum of understanding to join the program, Madam President. And so I urge him to go a little deep into the investigation and realize, because I can tell you, Madam President, that this program that has started, was operationalized in 2003, to date, Madam President, has in fact 106 witnesses in the program as we speak, together with about 99 dependents, with a total of 205 persons in the Witness Protection Program. Madam President, I wish to state even emphatically that to date, that program that has started under the PNM in 2003 and continued, is still in existence. To date, that program, no one has been harmed or killed in that program since 2003, Madam President, who has entered into the Witness Protection Program, who has signed the MOU. and understand the rules of the game, because they are established rules. One won't enter into the program.
One in there for 16 years.
That's right. And longer than that. I can tell you, Madam President, I was in charge of the Trinidad Tobago Defense, the regiment in Rambharat at the time of Clint Huggins. Clint Huggins was one of the witnesses in those programs, the early incarnation of that program. He was safe and secured while he was under the protection. It was only when he left that program voluntarily and went into the line, as we say in local parlance, went in the local parlance, when he left the program and he was executed. Once you stay in that program, and evidence is there, Madam President, once you remain in that program, the track record has shown quite clearly that the state has spent and expended quite a lot of money, because you're dealing with dependents and the participants themselves. And so once you remain in the program, so far we can say that you have guaranteed that they will be protected and you will be secured to be able to provide the necessary evidence to bring convictions insofar as what we are dealing with, Madam President. Madam President, and I would clearly like to say that the government will continue to invest in this program. The government will continue to provide the program, to provide the necessary support to those who are willing. Those who are willing, because again, I want to mention, Madam President, that we cannot induce or provide even reward or bribe.
Free will.
They must be of their free will in order to really treat the issues of criminality and crime. And we want to encourage and ensure that our track record shows that we can protect our state witnesses. We can protect them once they are willing participants, Madam President. Madam President, I thank you.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 10th of May, 2016 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, the 10th of May, 2016 at 1:30 p.m.